today's program online. And see, it is a need of time to get more and more knowledge about amendment in MTP and PCP laws. So this it has been done recently. So we must update our knowledge to avoid legal complications and to run our clinics and hospitals smoothly and with no fear and hand in hand with law. So perfect practice. So we have today experts team with us, Dr. Nikhil Datar, Dr. Viren Kulkarni, Dr. Dilip Walke, Dr. Kalpana Bariwanta as speaker. And they'll be highlighting about MTP and PCP laws amendments. And Dr. Dilip Walke will throw light on ART bill, surrogacy, and IVF. And there will be open forum where Dr. Meenakshi Deshpande and Dr. Vaijanti Patwardhan, they will moderate the discussion with Dr. Jayan Navrange sir, our own IMA Pune, our Rushitulya sir, and Dr. Dinesh Thakre sir, Dr. Ashutosh Jape, Dr. Santosh Kulkarni, and Dr. Chandrasekhar Sohni, and Dr. Prashant Chaudhary. I welcome all the speakers and delegates once again and invite you all for lamp lighting. So please join for the lamp lighting. So thank you all of you that you have joined our inauguration lamp lighting. Now I request our President, Dr. B.L. Deshmukh sir, to give his President's address.
Good afternoon, everyone. I welcome you all, Dr. Suhas Pingre, Dr. Mangesh Pate, and all. This important webinar cum workshop on PCP and new amendment in MTP and Act. I congratulate team IMA Pune and Dr. Vaijanti Patwardhan, Dr. Ashutosh Jape, and PMC health team, Dr. Ashish Bharti, medical officer, and Dr. Baliwant, AMO and appropriate authority for this department. This is an important issue which is very relevant to the gynecologists and radiologists, as well as all medical practitioners should know these laws. I welcome Dr. Suhas Pingre sir, Dr. Mangesh Pate sir, and all of you. About IMA Pune, this is the largest branch in Maharashtra and fourth largest branch in India, having more than 5,000 life members. I'm proud to say that sex ratio is highest in Pune. With these few words, I stop here.
Thank you, sir. So now Dr. Baliwanta madam join झाल्यात का? I don't think she has joined because she was
नाव आता दिसत नाहीये जॉईनच्या याच्यामध्ये.
मंगेश पाटे सर जॉईन झाले?
No, he is on the way.
On the way आहे ते.
Jape sir. I will request Dr. Jape sir to give a brief review about this workshop.
Thank you, Alka ma'am. I thank IMA State President, Dr. Suhas Pingre sir, IMA State Honorary Secretary, Dr. Mangesh Pate sir, Dr. Bharti, who is MOH of Pune, Dr. Kalpana Baliwant madam, who is Appropriate Authority of Pune, Dr. B.L. Deshmukh sir, President IMA Pune, Secretary Dr. Alka Kshirshagar madam, Chairman of Trust Board Dr. Bhutkar sir, Executive Trustee Dr. Patil sir, Dr. Jayan Navrange sir, all my seniors and my colleagues. PNDT and MTP are two laws which basically involve or rather govern gynecologists and radiologists. We are mostly concerned with it. Since last 3 years, we have seen that the sex ratio is increased all over Maharashtra, especially in Pune, like never before. We have today reputed and activist speakers with us. So it is going to be very interesting workshop. Now I hand over all the proceedings to Vaijanti Patwardhan madam. She'll say a few words. It's yours, ma'am.
Respected State President Dr. Pingle sir, IMA Pune President Dr. PL Deshmukh sir, my co-convener Dr. Ashutosh Zape, Trustee Board Member Dr. Sanjay Patil, all the office bearers of IMA Pune, Dr. Balivant Madam, Dr. Bharti sir, and all the colleagues from IMA as well as corporation, Pune and PCMC, and all the attending delegates. A very good afternoon to all of you. It's a pleasure being with all of you today, this afternoon. All of us know the legal issues which are associated with while practicing our medical profession. MTP, PNDT, these two are one of such two very, very important acts. And recently, there have been very good changes which are incorporated in the act, and for which tremendous efforts were put in by the organization, especially MTP Act. And I'm really happy that we got the opportunity to organize the workshop, which is related to the amendments as well as the compliance by the medical professionals. And of course, we do have an open forum because all of us have many questions while practicing the act. So I hope this workshop will give all answers to most of the questions which the practicing doctors are facing. And I really thank the appropriate authority for all the kind support extended for organizing this particular workshop, and to IMA State as well as Pune branch. So welcome to the workshop, and hope that the sessions are going to be very interesting and informative. Thank you.
Thank you, Dr. Jape sir and Dr. Vaijanti madam. I think Dr. Mangesh Patil sir has joined. I think many of
नाही मॅडम नाही जॉईन झालेला मंगेश.
So I will request our State President Dr. Mangesh Patil sir to I will request our State President Dr. Suhas Pingle sir to give his opening remarks as a presidential address.
Thank you, Dr. Altaf Sagar, Secretary, IMA Pune branch. While wishing all the success to this very important topic, I take note of President of Pune, Dr. Deshmukh, the dignitaries and officials from the municipal corporation, trust board members of IMA Pune branch, Dr. Budkar, Dr. Sanjay Patil, Dr. Naurange, the chairperson of PCP Maharashtra, Dr. Jape, and chairperson of WDW, Dr. Patwardhan. I remember as a member of Maharashtra Medical Council, especially PCP Act, there were many cases slapped on the doctors. I know way back in 2008, we used to conduct workshops for doctors to enlighten them and teach them how to fill up the F form and other matters, Many times we take these record keeping very lightly and then pay heavy price. I remember 10 radiologists from Pune were convicted. They paid 1,000 rupees as penalty because it was the first time. And the problem was a clerical one only. They had forgotten to renew their licenses, So it is my sincere request that this important program will give you insight and you will put it into practice. So again, I wish all the success for this program and especially thank the IIMA Pune office bearers, including the President-elect Dr. Meenakshi Deshpande, the chairpersons of Maharashtra, but who are basically IIMA Pune members, that is Dr. Jape and Dr. Patwardhan, for all the efforts they have taken to register so many members for this program. Thank you.
Thank you, sir. It was a real well said. We have taken efforts, but still people are joining for this online workshop, and it will be a very helpful for all the practicing gynecologists as well as radiologists as well as all the practicing physicians. So now I request Dr. Gitanjali Sharma to give vote of thanks. She's a so I'll hand over the mic to her.
Thank you, Alka Madam. On behalf of IIMA Pune, I, Dr. Gitanjali Sharma, Joint Secretary of IIMA Pune, wish to thank all the dignitaries who have attended the inaugural function for today's workshop. My special thanks to State President, Dr. Pingle sir, for taking out time specially and giving such nice words. My thanks to Dr. Ashish Bharti and Kalpana Balivant Madam from the Health Department of PMC. Vaijayanti Patwardhan Madam and Dr. Ashutosh Jape, special thanks to them because they are the conveners and they have taken a lot of efforts to make this workshop possible. All the faculty and delegates who have joined for today, President Deshmukh sir and all the office bearers of IIMA Pune who have joined. So I thank you all and we are looking forward to an excellent workshop for today's on medical legal and on especially on MTP and Pcp and DTI. So over to you, Alka Madam, for the further scientific sessions.
Thank you, Gitanjali. Now we'll start our scientific session. So I will hand over to Dr. Ashutosh Jape and Dr. Vaijayanti Patwardhan to conduct the further sessions.
Yeah, today we will commence with
Dr.
first
Jape,
lecture.
Dr. Jape,
Yes, sir.
I am very happy
Yes,
to
sir.
note that we have finished this inauguration program before time, because generally people are not
Yes, sir.
interested in such inauguration programs, you know. And I don't know the joint secretary who did the sweet job of thanking all, you know. So I could not take note of her. Thank you.
Yes. Thank you, sir.
Thank you, sir. Thank you very much. So we will start with Dr. Viren Kulkarni first. He'll be speaking on the PCP law and amendments, the recent amendments. And Dr. Viren Kulkarni is a practicing radiologist since last 20 years in Pune. He's an interventional and fetal radiologist, and he's also past president of Pune Radiologist Association. So Viren, over to you.
तुम्ही याच्यावरनं बोलताय का तुमची?
नाही.
There will be only slideshow.
शेअर्स नाही ऑलरेडी.
Okay.
तुमच्या विचारामध्ये कन्फर्म करेल का?
All respected seniors and my friends. Hope I'm audible. Am I audible?
Yes, you are audible.
Okay, so I'll be speaking on PCP Act and recent amendments. I'm sure that every one of us is aware of all these act and amendments, but still, I think it is necessary to have the revisions of PCP Act so that we should not face any legal actions. Which one? Okay. Sorry for that. To begin, we have to understand why this PCP Act is necessary, why it came in place, and most of my lecture, the beginning part of the lecture, is actually copied from the book, the PCP guidebook provided by the government and the Act book. The reason being, this is the Act, and I don't want to misplace any of the words in the Act. So this is actually copied. So a gender bias sex selection is a complex issue emanating from web of social, economic, and cultural factors, which includes preference of son over daughters, access and availability of technology and its misuse, and the desire of couples to have smaller families but not without sons. The practice has existed in India for centuries, but now assumed alarming proportions. The child sex ratio, which is calculated as 1,000 girls per 1,000 boys in 0 to 6 years age group, has shown steep decline. We are all aware of that, and that's why the Act came into picture. Ashutosh, I need help. The obsession of son. This is actually obstructing. The obsession of son is the reason behind tremendous psychological pressure on women. Such pressure also manifests itself in the form of bigamy, the desertion for women's perceived inability to bear a male child, impacting their reproductive, mental, and physical health. Evidence from states with skewed ratios, like Rajasthan, has shown that the practice of gender-biased sex selection could lead to increased violence against women, bride trafficking, the resurgence of practice such as polyandry. So, with this background, it was necessary to form an act which can provide for the prohibition of sex selection before and after conception, and for regulation of prenatal diagnostic techniques for purpose of detecting genetic abnormalities, metabolic disorders, chromosomal abnormalities, and certain congenital malformations. Prevention of their misuse, this is important. Prevention of their misuse for sex determination leading to female feticide and for matters connected herewith. So the object of the Act was, it was proposed to prohibit prenatal diagnostic techniques for determination of sex of the fetus leading to female feticide. Such abuse of technique is discriminatory against the female sex and affects the dignity and status of the woman. A legislation is required to regulate the use of such techniques and provide deterrent punishment to stop such inhuman act. So it was decided to have an act in 1994, which will see there is a repetition because this is a big act book. The words are repeated, but we'll have to read it that way. Prohibition of misuse of prenatal diagnostic techniques for determination of sex of the fetus leading to female feticide. Prohibition of advertisement of prenatal diagnostic techniques for determination of sex. Permission and regulation of use of prenatal diagnostic techniques for the purpose of detection of specific genetic abnormalities for disorders. Permitting the use of prenatal diagnostic techniques only under certain conditions by the registered institutions, and punishment for violation of provisions for proposed legislation. So In the formation of this law, the law book describes 8 chapters and rules. The first chapter describes short titles, extent and commencement of the definitions. Second chapter describes the regulation of genetic counseling centers, genetic laboratories, and genetic clinics. The third chapter describes the regulation of prenatal diagnostic techniques. Fourth chapter describes the Central Supervisory Board. Fifth, about appropriate authority and advisory committee. Sixth, about registration of genetic counseling centers, genetic laboratories, and genetic clinics. 7, about offenses and penalties. 8 is having some miscellaneous things, and thereafter rules. All the information is available in this book. Be updated with this 2020 book, Act book. To discuss the sections in the chapters of the Act is beyond today's presentation, because if we go every chapter wise, all the section wise, it will take, believe me, not less than a day. However, we will discuss the important points which are necessary for our day-to-day practice and what needs to be followed, basically to save ourselves from any legal action. In chapter 3, which gives us information of regulation of prenatal diagnostic techniques, this is one of the important sections, section 4. It says, there are again subsections in this, 1, 2, 3, 4, 5, which actually tells us about no place, including a registered genetic counseling center, genetic lab. I'll not make it boring, because see, it sounds as if, there are repetition of words. So I will just tell you the crux of it and the important part of it. Unregistered centers, this describes actually it should be registered. Second, the diagnostic techniques shall be conducted except the purpose of detection of any of the following. And then there is a list which we can do actually prenatal diagnostic techniques in these conditions, but not for sex determination. When the age of the pregnant woman is more than 35, so there are certain conditions. But this is important slide. We will read it word by word. Provided that the person conducting sonography on a pregnant woman shall keep complete record thereof in the clinic in such a manner as may be prescribed, and any deficiency, mind you, or inaccuracy found therein shall amount to contraventions of provisions of section 5 and section 6. So what this section 5 mean? It describes about the written consent of a pregnant woman and prohibition of communicating the sex of the fetus. Section 6, which gives us information about determination of sex prohibited. So you understood that? Section 5 and section 6. So any of the deficiency or inaccuracy found in record is actually amount to contraventions of provision of 5 and 6. This is how the law is, unless contrary it is proved by the person conducting such a sonography. So there is no loophole, no outway. You have to maintain the record completely. And in another chapter 7, which describes the offenses and penalties, the section 23, another section which is very important, says, we'll again read this by word by word. Any medical genetist, gynecologist, registered medical practitioner, or any person who owns a genetic counseling center, genetic laboratory, or genetic clinic, or is employed in such a center, employed also, laboratory or clinic, renders his professional or technical services to or at such a center, lab or clinic, whether on honorary basis or otherwise, and who contravenes any of the provisions of the Act or rules made thereunder shall be punishable with imprisonment for a term which may extend to 3 years, and with fine which may extend to 10,000 rupees, and any subsequent contravention up to 5 years and 50,000 rupees. So word any is very important. Who contravenes any of the provisions. So we'll have to see, get into all the details provisions. The second subsection of this section 23 says the name of the registered medical practitioner shall be reported by the appropriate authority to the state medical council concerned for taking necessary actions, including suspension of the registration if charges are framed by the court until the case is disposed, and on conviction for removal of his name from register of the council for the period of 5 years, his or hers, for the first offense and permanently after subsequent offenses. Any person, now this is for the relatives, any person who seeks the aid of any genetic counseling center, genetic lab, genetic clinic or USG clinic, or a medical geneticist, gynecologist, sonologist or imaging specialist or RMP or any other person for sex selection or for conducting prenatal diagnostic techniques on any pregnant woman for the purpose other than those specified in subsection 2 and 4 shall be punishable with imprisonment for a term which may extend to 3 years and fine which may extend to 50,000, and subsequent again for 5 years imprisonment and 1 lakh rupees. So this is also important. But what happens, usually the doctor will not complain against the patients coming to them and asking for this kind of act. This is very interesting. For the removal of doubts, it is hereby provided that the provisions that are in the subsection 3 shall not apply to the woman who was compelled to undergo, since it is thought that the woman who is pregnant and want to be a mother will never wanting to do sex determination. That is what this act says, and she is completely spared. So this section 3 is about the relatives and husband, but section 4 spares the pregnant woman from any of the punishment. Why I said this is interesting, this is really sensitive thing. Sometimes we have to appreciate the lawmakers, that how sensitively they handle the things. So knowing these two sections, section 4, I'm repeating this, section 4 and section 23, which are most important, we should understand the compliance for the provisions of PCP Act. Again, I'm very sure that everybody is well aware of this, but still no harm in repeating this. You have to mug this, print this, keep it in your clinic, read every day, because this is going to prevent you from any legal action. So for the compliance of provisions of PCP Act, it says that sex selection or detection or disclosure is prohibited. Records should be maintained. Thanks to Dr. Ashutosh, actually these slides are copied from him. So when I was reading about the sections in the Act book, it sounded boring, right? Because they use a kind of language which is more of suitable for the advocates and lawyers. So whenever we pick up the book to read those sections given in the law book, it becomes boring and most of them don't read. So Maharashtra government was very kind to understand this problem of doctors, and they came up with a guidebook which was published in 2015, and in simple words they described everything, how to be compliant with this PCP Act. So we'll go one by one. In short, I'm going to tell you, but this is very important. Registration of the clinic is important. Registration of clinic, it can be done by paying the fees of 25,000 for clinic and 35,000 for the hospital. The registration is non-transferable. Certificate of registration, which is given in duplicate, to be displayed at prominent places in clinic. The registration should be renewed after 5 years. The application of the renewal should be done 1 month in advance, but as the advisory committee meeting is every 2 months, it should be minimum 2 months in advance. Application of registration should be made with affidavit containing undertaking that the facilities will not be used for selection of sex of the fetus except for the diseases specified into section 4.2. All this information is available with you anyways. Ultrasound machine or any other equipment shall be purchased from a registered company only. Important. The changes in the employee, place or equipment should be informed to the appropriate authority 30 days in advance. Display of the board in premises, it should be in English and in the local language, stating that disclosure of sex is prohibited by law. No particular size of the board is defined by the law, but in Pune at least, in the advisory committee meeting, the size was decided to be 4 by 3 feet to be displayed in the USG room as well as in the waiting hall. There will be inspection of the clinic once every 3 months for the records. Copy of the PCP Act should be available in the clinic and should be made available for the pursuit of the visiting persons. It is better that you keep a copy in the local language also. All the further records are to be preserved for 2 years or till the disposal of criminal proceedings, if any. The referral sheet of the doctor sending patients for sonography should be on his letterhead duly signed. For self-referral copy of the case paper should be preserved with the referral note. Consent of the person undergoing sonography should be taken prior to start of examination. The doctor performing the procedure should give his declaration. Form F should be filled completely. Any person conducting sonography or image scanning on the pregnant woman shall give a declaration on each report as she has neither detected nor disclosed the sex of the baby of pregnant woman. Every registered center will send a monthly report till 5th day of the following month to the concerned appropriate authority. This is not in particular format, but yes, it is mentioned in the PCP Act. And maintenance of 5-column register. The 5 points are serial number, name of the patient, address of the patient, name of the spouse of the patient, and date of the first visit of the patient. So we used to do this all record keeping in manual way, but recently last few years, the software companies made very good softwares, and which is very important to ensure the complete filling of Form F. This software helps us for correct information of the patient, consent of the patient, declaration of the doctor, 5-column register, date of first visit to the patient to the clinic. Also, if the software is used, there is no discrepancy in the record maintained of Form F filled online. So, if possible, buy a software which will help you. Now, as we have gone through the provisions of PCP Act, as I showed you, I'll repeat section 4, section 23, and then we have seen that how to be compliant with the provisions of PCP Act. We have to understand this. Fortunately, the law do not discriminate between any minor unintentional error in record keeping and actual act of the sex determination or disclosure. The penalties for any contraventions are same. I will show you the slide again, 23, and I showed you this. Section 23 says any contravention. So this is very important. Though there are two different spectrums, I am saying spectrums because these two are different things, but not in the law. Till now, whatever slides I showed you were copied from the law book, copied from the guidebook given by the government. So the wording, I tried to be whatever this says, but the slides after this will give us some thought which will tell us, is it going right way? I'll come back to these slides. Two spectrums I was describing. Any small unknowingly done mistake in the maintenance of record, mind you, but the sex determination is not done, versus sex determination is done, where the records are not kept at all and very well or otherwise very well maintained. But there is no discrimination because the law says, unfortunately, that you have to follow the provisions, and if there is any single mistake done in your record keeping will contravenes the law. So be compliant with the provisions, keep your records well. I'm just going back to the slide number 1, where we had that introductory part of the PCP Act, where I was telling you why the law came in picture, why the law was actually formed. It is proposed to prohibit the prenatal diagnostic techniques for determination of sex of the fetus leading to female feticide. Now, I'll read it little slowly. Understand this. Such abuse of techniques is discriminatory against the female sex and affects the dignity. Important words. It is discriminatory. It affects the dignity of females and status of the woman. It's inhuman act to do female feticide. With such a sensitive lawmaker who made this law, and actually it was implemented such rigorously all over India, especially in Maharashtra. Still, the law which is made with such high values, still why these questions I have in mind. Most of the doctors, they have in their mind. Why results, expected sex ratio is not achieved even after strict implementation of the act for record maintenance? Why real culprits are getting escaped? And why sensitive professionals are in fear? Why they are in fear with this act? Actually, if the act is made with such high values, right, which says that it is against discriminatory against female sex, affects the dignity, and that's why to protect that this act was made. And still the sensitive professionals are in fear. This is something not acceptable, right? But I'll go the further slides which will tell us why this is happening. Few solutions. These solutions are actually not my solutions or not anybody's solutions, but I think over the period we are following this law in almost 20 years, 25 years, discussed with many lawyers, discussed with many advocates, discussed with many senior doctors. Probably things are going somewhere where we can stop them and actually get the good results out of this act. So the solutions, even if I'm saying these are not the solutions given in the law, so we have to really understand that my presentation is having 3 parts. Okay, the introductory part, which was giving us the reasoning why this act was formed, and then the provisions, and the provisions how to follow them strictly, the compliance, and the solution part is actually we have to think over, all of us. So the record keeping is important, yes, at its place, as it is definitely helping in sensitizing the people and professionals about the act. Now this is important. Why record keeping is important? You know, when we display a board in the clinic and then we keep a law book there, we get a form signed by the lady, so she understands that this is under law, this is wrong. So definitely it helps in a way to sensitize the people, and it definitely helps to sensitize the professionals. Yes, errors in the record keeping should be punished, undoubtedly should be punished, and already the law says that. But this is the small solution. The errant should be punished with heavy fines or suspension of registration of the center for a few days. Yes, but the legal case should not be filed against, even if the law is saying that, because what I am trying to tell is, understand, there is a difference between fine and tax. When I'm saying that errant should be punished with heavy fines, Fines is something we pay for doing wrong, right? But the tax we pay for doing something good, isn't it? So what I'm trying to say is here is that yes, there should be a heavy fine if there is any small error in the record maintenance, or you can suspend the registration center for 2 days because there is no sex determination done in these particular things. But please don't tax them by filing a legal case. The minor error in record keeping cannot be the parameter or can't be equated with sex determination. Hence, no legal action like filing a legal case, as there is no intention of sex determination or hiding something, because the record is already kept, but yes, there are minor mistakes in it. Ultimately, this is not just helping the professional who is already fear, but this will actually help to reduce the burden of the legal proceedings on the judiciary system and concerned government officials. Yes, so I think we need to understand this. Further, with few solutions, again, I am repeating, these are not given in any of the law, okay? But senior doctors, with officers, with advocates, and with lawyers, we think this will give us some kind of, target-oriented and real implementation of the act. Few solutions here, the strict action should be taken, where we can say the legal action or filing the case against those unregistered centers, non-filling of Form F while doing obstetric USG. Non-filling means not filling at all, and actual sex determination or disclosure where people are doing wrong practices. Why I'm saying this? Because see, running unregistered centers or non-filling of the Form F definitely raises the doubt of intention of sex determination. We don't know whether they're doing it or not, but yes, it raises why you are running a registered center, why you are not filling a form. But if you are filling the form, your record you are maintaining, and there are small deficiencies, it all the more rules out that there is any intention of sex determination. Nobody is so fool that doing wrong practice and keeping the record as well, which is actually incomplete. So when we are saying the strict action or legal action should be against unregistered centers or non-filling of Form F or actual sex determination, how to grab them? Only decoy cases will help. Every 3 months, even if the officer is coming to our clinic and checking all the record, you cannot catch hold of these people. Only decoy cases will help. Fourth thing, where I keep listening to Patwardhan madam in IMA, that she always raises this point, and very important point. I remember she raised this point some 5-7 years back. The punishing involve parents and relatives effectively and giving wide publicity to media through this. This will all actually deter the people who are wanting to get sex determination, who are wanting to do sex selective abortions. Important point, yes. So actually that is the end, but then there is something which is extension of this PCP Act amendments. I'll just go through the amendments. The law was formed in September 1994 as PNDT. And thereunder rules were framed in 1996. First amendment was done in 2001 in the Act 32 by formation of Central Supervisory Board. This board by common consensus can suggest changes in the Act to the Parliament. Important point. See, now whenever you want to do amendments, if this supervisory board is sensitive enough and understand the doctor's plight and everybody's plight, that they can always do the amendments by telling it to Parliament. In 2003, PNDT amended as PCP adding preconception techniques under law. In 2014, rules were framed for 6 months mandatory training after MBBS to perform obstetric sonography. And 2019, Jammu and Kashmir also came under purview of PCP Act. Now, these are the amendments already done. But still, for effective implementation of this act, I think we seriously need few amendments to improve the sex ratio in India. Because the present act provisions are proving. So this is a different angle I am giving. The present act provisions are proving very poor to catch hold the real culprits. Also, the penalties for actual sex determination is very less according to me. Now, this may be a point where people might have arguments. I'll explain. See, as I repeatedly said in the presentation, that present act provisions, under these provisions, the cases were filed on doctors, many doctors all over India, many doctors in Maharashtra, but it is proved that it is very poorly catching those real culprits. And the second point I am saying is that the penalties for actual SD is very less. How many of you are aware of this? I don't know, but 3 days back, a doctor from Parli is convicted for doing MTPs on 23rd of February, I think. Aurangabad High Court gave him punishment of 4 years for doing MTPs, which were wrongly done after sex determination. I know a few of you must be knowing, after doing thousands of abortions, which were sex-related abortion, do you think that it is justifiable that only 4 years of imprisonment is... So this is the point, that the penalties for actual SD are very less. On the contrary, similar punishment is given to the doctor who is falling short or with minor mistakes in record keeping with no intention of sex determination. So this is the time we have to really think. A law-abiding doctor, actually a law-abiding doctor, are feeling harassed and facing disproportionate punishments for unintentional minor mistakes. I'll explain you this also. I'll give you some examples. A lady doctor when I'm saying this word harassed, that doesn't mean they are harassed every day. But see, what is happening actually, a doctor from PCMC, I remember, she is facing a conviction of 1 year of imprisonment for not signing a single form for a pregnant lady. She was 6 weeks pregnant. Now, all of us are aware that even if, let us see, the doctor is at wrong practice, the doctor is in wrong practice. How can the doctor determine the sex of the baby at 6 weeks? All of us are aware that sex can be seen only after 12 to 13 weeks. Now, this is what is harassment is. Every day when we are practicing in our sonography clinics, we have to sign a declaration saying that I have not done sex determination disclosure to anybody in any manner. We are signing so many forms which are less than 12 weeks. So in a way, the declaration is wrong, right? When you cannot do, how can you disclose? But every day we have to sign the form, keeping our brains aside. So that is kind of harassment for a sensitive doctor. Why amendments are necessary? Again, the third point, the government machinery, the judiciary system is overburdened because of that. Yes, I do understand, all of us understand the intent of the act is in place and valid. However, sensible implementation will give focused results of improving the sex ratio by catching the real culprits. Undue importance to minor errors in record maintenance will improve the records, but not the sex ratio. The role should be limited to sensitize the professionals of the act, which is fairly achieved, I will say. Thereby, gradation of the punishment is an automatic, obvious outcome of properly implemented act. I'm done with my presentation, and this last slide I'll just read out. Justice will not be served until those who are unaffected are as outraged as those who are. Most of you are thinking this slide is related to the PCP affected people and PCP unaffected people. No, this slide is actually only for those females in India who are affected because of the traditions, because of the problems they are facing to have sons and compelled to do abortions. So this slide is not for doctors. Okay, so don't think wrong way. I'm done with my presentation. I'm going to take the questions now.
No,
So we'll have the discussion at the end. Thank you so much. One thing I really want to mention in this, one thing which is important, that when I was talking about the sensitivity of the act, the word given to the authority is appropriate authority. Mind you, I was just thinking why the word appropriate is given to the authority, because appropriate authority is not just appropriate authority by her qualification or by the papers, but she is appropriate to act on this and to differentiate between things and to act sensibly. We are very thankful to have such a appropriate authority in Pune for last few years, since 2017. Baliwant madam, I should congratulate, and I have no hesitation saying that the act is really implemented so wisely. Doctors are feeling safe. It is not just, I will add one word before doctors, are sensible and law-abiding and innocent doctors are feeling safe. And actually the sex ratio is gone high in Pune. It's gone to 941, the recent figure. So I think, thank you, madam, for that. Again, I'll come to this appropriate word. This word really suits you, ma'am, because this is a real appropriate authority. Now, it's not just authority, appropriate authority. Thank you so much. And I'm just done with this, my presentation. Thank you so much.
Thank you, Dr. Viren Kulkarni. I will request our president, Dr. B.L. to felicitate you.
Yeah, Ashutosh will take over.
Sir, this is bouquet for you.
I may upar na. Yes, Dr. Jape, you can start for the second introduction.
Yeah. Thank you. Stop share. Thank you, Dr. Viren. And a very valid point mentioned by you was how the sex ratio of our own city, Pune city, is increased to 941, which is a record. And we really need to thank and congratulate PMC Health Department and appropriate authority. Dr. Baliwant madam, special thanks to you. And definitely compliance has been very good from the doctor's side also for the city, as well as the implementation also. And now there is a good understanding of the practitioners also related to the compliance with respect to PCP Act. Now we move on to the next session for for today, and that is by another star speaker, I would say, and that is Dr. Nikhil Datar. Being a gynecologist, and whoever is in our delegates, who all are the gynecs and practicing, running the MTP centers. We all are really thankful to all your efforts, sir, Nikhil Datar, sir, and it's our pleasure to have you here for this particular session. I think this could be the first time you're speaking on the IMA's forum, and IMA Maharashtra State and IMA Pune. We really we thank you and welcome you to this forum. Nikhil Dataranna, me म्हणीन की I just was going through his CV, and one of the extraordinary awards, which I would say to his credit is being felicitated as Mehmane Watan award by Sindh government of Pakistan. I think मला तरी अजून दुसरं कोणी असे आपले फ्रेंड्स माहिती नाही ज्यांना अशा प्रकारचा ऑनर मिळालाय आणि I will definitely I feel that I award असं फॉर्मल म्हणून तुम्हाला मिळालं नसेल तरी फ्रेंड ऑफ गायनेक्स अँड फ्रेंड ऑफ MTP सेंटर्स हे अवॉर्ड तर नक्कीच आम्ही प्रपोज करू तुमच्यासाठी. सो बिकॉज ही इज अ पर्सन हुज अनटायरिंग अँड डेडिकेटेड अँड नेमकेपणाचे एफर्ट्स they have been instrumental in getting out the very welcome kind of amendments in the recent MTP Act, which have been passed very recently. So just to give its brief introduction, तुमचं नाव सगळ्यांना माहीतच आहे सर, पण तरी I would like to formally introduce you. And he's basically a practicing gynecologist who is also a legal expert, and he's the medical director of Cloud9 group of hospitals in Mumbai. And he's a founder, president of Patient Safety Alliance. And he's also the consultant and director at Lifewave Hospital in Yashda Hospital, Mumbai. And he's a visiting professor to Maharashtra National Law University. And so he is an equally competent authority with respect to the law also. He's a health right activist whose judicial activism has paved way to the amendments in MTP Act, which all of us are very well aware. He's received many awards and recognitions. To name a few of them: Commonwealth Professional Fellowship by UK, then the B.N. Purandare Gold Medal, and Dr. Dastur Gold Medal, which he was awarded. So Dr. Nikhil Datar is with us, who will be talking about the recent amendments in the MTP Act. And thank you, sir. And I hand over to you.
Good afternoon, everybody. Can you see my slides? Are the slides visible now?
Yes, sir.
Okay.
Yes, we can see your slides.
Yes.
Okay. All right. First of all, my heartfelt thanks for this kind invitation. And I'm sorry that I got a little delayed with my OPD work and all that. So that's why I got a little late in joining. Thank you, Madam Patwardhan, for inviting me, and thank you for your very warm introduction. I have about 20 minutes at my credit, and probably I'm going to take you through the current scenario, current steps as far as the MTP is concerned. Madam has already said this particular thing, that it is basically my case. And by the way, my case, Dr. Nikhil Datar versus Union of India, which has begun from 2008 and which is still going on. And at the end of my presentation, I will tell you why it is still going on, which has brought in a significant amount of change to the MTP Act. So I'm going to share with you the journey, and some bit of the journey I want to share because there are significant amount of questions even today in the minds of the people. So I want to make you understand what has been the story so far, what have been the kind of judgments so far, and where are we in terms of the amended law, whether the law has done enough or whether there is still any room left, for the amendment that probably could be made. Now, I want to make it extremely loud and clear that doing a termination of pregnancy going beyond strict sense of MTP Act is an extraordinarily medico-legally risky proposition. We have been doing it. Lots of gynecologists in our country have been doing it under the garbs of calling it as a stillborn and severe prematurity and calling it as natural labor and all that kind of thing. But let me tell you that in few days you will hear a judgment that will be delivered, okay, against one extraordinarily senior gynecologist from Delhi, whereby she ended up terminating a pregnancy beyond 20 weeks for a chromosomally abnormal baby. The mother has succumbed to death, and she will be penalized for this particular thing, sadly so. The truth behind it is that Indian penal code in our country is very clear that causing termination of pregnancy is not allowed. MTP Act came in force in 1971. MTP Act carved out an exception to the larger law of Section 312. But MTP Act is extremely clear that you are allowed to terminate the pregnancy strictly under the conditions that have been laid down under the MTP Act. If you bypass or go beyond the ambit of the conditions that have been laid down, then you will be prosecuted criminally. You can be put behind bars. Your registration can go cancelled. And that is why it is a humble request with folded hands that whosoever says whatever, there are good number of lawyers today who say you do what you want to do, we will save you. Please don't come into their jasa, and please strictly follow the MTP Act. Even if the MTP Act is unjust, please follow it. Don't try to do unnecessary things in interest of the patient, because unfortunately if something goes wrong, it is going to boomerang back onto you only. So please follow the rules to the T. This is the first case, and everybody knows this case, commonly known as Nikita Mehta case. The first case that the whole journey began, as far as I am concerned, Nikhil Datar versus the Union of India. Others means Nikita Mehta and her husband. And this is where we primarily speaking went to the court long time back. And since then, this particular case, Nikhil Datar versus Union, is still there in the Supreme Court, and I have been fighting this particular case. In 2016, we got our first breakthrough, at which time, at 24 weeks, the Supreme Court allowed termination of pregnancy. Of course, this was an abnormal baby and anencephalic baby, but it was 24 weeks, and we took permission even in spite of it being 24 weeks, but anencephalic baby. We went ahead, took the termination order from the Supreme Court, which was given to us, and that's how termination beyond 20 weeks started becoming a norm. Over a period of time, the next case came to me, referred from Kolkata. Our friend Dr. Bhaskar Pal, gynecologists in the audience would know Bhaskar Pal. He is from Kolkata. His friend's daughter, diagnosed to have 24 weeks fetus with multiple congenital cardiac abnormalities. Now, mind you, cardiac abnormalities can technically be treated. Some surgeries can be done, but the outcomes are very poor. And this was the first ever case where technically not so very non-compatible to life scenario was in front of the court, and Dr. Devi Shetty came to our help, and with his opinion we could convince the Supreme Court that termination can be done even if there is some kind of a treatment which is possible. Even in that case, termination at 24 weeks is possible, and none other than Justice Dhananjay Chandrachud delivered this particular judgment. After that, there has been series of cases. At this point of time, we have close to about 300 plus cases which we have dealt with in various high courts and various Supreme Courts. And mind you, these cases also include minor rape survivors. And we have got orders of termination of pregnancy for most of these kinds of cases. Ultimately, it was like a modern satyagraha that we created. We choco-blocked Supreme Court with so many cases that ultimately Supreme Court said that please don't come to us, please go to your respective high courts, please allow us to do our own work. So after that, we started filing cases in the Bombay High Court, particularly for Maharashtra and various other high courts, and close to about 300 plus cases. And mind you, I'm happy to say that, and with an honor, I want to say that I have helped all these 310 women pro bono without charging a single rupee from them. And I have got orders for the terminations of pregnancy. And most of these terminations of pregnancy have been done in the government hospitals, because most of these women were not affording people, and we saw to it that they were given termination of pregnancy free of cost at government hospitals. This one case I want to highlight, the first ever case where beyond 20 weeks, I have done fetal reduction or feticide under ultrasound guide. And you can read this. I did it at Cloud9 Hospital under ultrasound guide. I put in KCL, I stopped the heart sound, and this particular termination of pregnancy was done with the sanction of the Bombay High Court. So I want to drive home this message that feticide can perfectly be done. There is no problem in terms of doing this particular procedure. This has been done by me and has been done on regular basis at this point of time. Well, there were few cases where termination was not allowed, and I want to highlight these cases because now again we are going to have, as after the amendment, these government bodies and permanent medical boards, and we are likely to face the same challenges that we faced some time back when we were trying to convince the various boards and all that kind of thing. Now, a lot of people in the government are under the impression, as in not government, but in general also, that a lot of people are under this impression that termination can only be done for those cases where there is no treatment that is possible. So it means that they think that only anencephaly, absence of kidneys completely, single ventricle, only these are the cases where termination is allowed, but that's completely wrong. Any of those kinds of abnormalities where there is a substantial and serious fetal handicap that is likely to be the case, termination of pregnancy is very much possible, and that is why this is what is very important. We had one case of a 30-year-old minor rape survivor. Her termination was done at 32 weeks of pregnancy, and just about last week or 10 days back, we had one judgment from Kolkata High Court where termination of pregnancy for Arnold-Chiari malformation type 2 was allowed at 34 weeks of pregnancy. So I want to drive home the message that a lot of people are under the impression that beyond 24 weeks termination cannot be done. Even after the law has been amended, termination of pregnancy can be done after 24 weeks of pregnancy. Of course, there are limited conditions, there's a way to do it, but that's how it is supposed to be done. The biggest trouble when things did not go well, I mean, I'm talking of my experience when certain cases where there were the so-called boards, the medical boards did not allow us to terminate the pregnancies, but I'm sure the same kind of a challenge we may face down the line amongst the permanent board members. So through IMA, I want to pass on this message to all those, if there are any government officials or government doctors who are attending to this particular program or this particular lecture, that please try to understand that we as the doctors, whether we are in government or in private, we are not supposed to make our moral stand anywhere. Lot of doctors are unclear about MTP. Lot of doctors are unclear about when to do MTP. Lot of doctors are unaware of many facts about MTP. So such kind of fearfulness and hence defensiveness is not going to work. I had one such case, Down syndrome. Pediatrician said, where is the problem? Down syndrome babies can stay alive for a long period of time. Why do you require to terminate the pregnancy? If you allow Down syndrome to be terminated, the pediatrician was so insensitive in that government board that she said that it will amount to reproductive materialism. I mean, without giving any importance to the plight of the pregnant woman, plight of the pregnant or the family. I mean, she said that we can treat Down syndrome, as in we can give treatment, the child can stay alive. I mean, so we are not here primarily to be pro-life, pro-choice, pro-life, all that kind of ideology. That's an individual's ideology. Our job sitting there as a part of the committee is only look at the law, only ensure that whether termination can be safely done at this point of time or no, and ensure whether it's a substantial abnormality or no. That's the only job that we have got to do, and no other job that we are expected to do. And that is why ultimately in this particular case, Suvarna Darekar versus Union of India, Bombay High Court ultimately brought in terms of reference as to what all the considerations that have to be taken into mind before any judgment or any order is passed by these people who are sitting in the board. And please read this, that abnormality as to substantial, termination should not be more risky than childbirth. Now, mind you, again, a lot of people are under this impression, oh, beyond 20 weeks termination will become more risky. Now the law is up to 24 weeks. Now they are saying beyond 24 weeks termination will be risky. We have to understand that if we do not terminate the pregnancy, the lady will reach 9 months and she will have the process of childbirth. So the question is termination today more likely to be risky than childbirth? If that is the answer, yes, then you will not terminate. Let me give you an example. Imagine that today I have got a woman who is pregnant, who is 24 weeks or 26 weeks, and let us say she has got a very tight mitral wall lesion. let's say mitral stenosis. Now, if I try to terminate her pregnancy today, it will be definitely much more riskier. But I have got couple of months in which time frame I can treat her condition of mitral valve, whatever lesion she has got, let's say mitral stenosis. So in short, her childbirth after 2 months might be less risky than trying to terminate her pregnancy right now. In such a situation, nobody is trying to tell you that you should still terminate the pregnancy. The consideration has to be only one, whether termination is more risky than childbirth. Don't compare termination with 20 weeks, 14 weeks, 12 weeks. That way, lesser the gestational age, less risky it will be. That is the obvious. Everybody knows that particular thing, that higher the age advancement of gestational age, more troublesome the termination becomes. But it does not mean that just on that ground, you are going to kind of not allow termination of pregnancy to happen. So that is not what is expected by the law. 1 second, I think, yes, okay. Now, I want to show a photograph of this particular affidavit which Government of India had to file in the Supreme Court in my matter. And in this affidavit, Government of India had to say that they are willing, because I had a data of 300 odd cases in front of the Supreme Court. So Government of India had to say that they have no other alternative but to consider petitioner, that is my demand for appropriate amendment of the MTP Act. In the meantime, Government of India framed certain guidelines for the purpose of reference to the various medical boards. So till such time, the law was not amended, there was a good 5 to 6 years time frame in which we used to approach the court. Court used to send the patient to one of the government hospitals where medical boards were formed. Medical boards were supposed to follow these guidelines from Ministry of Family Welfare, and on that basis they were supposed to write the report, and the report was sent back to the court, and court used to allow termination of pregnancy. So if you read this particular guideline, it is crystal clear that termination late in the pregnancy is quite perfectly all right for fetal abnormalities. Even late termination on the ground of rape is perfectly all right. Mind you, these were only minor survivors, not a major survivor. And in the same guideline, there is this particular mention that in case of pregnancy beyond 24 weeks, ultrasound guided procedure of giving KCL and stopping heart sounds is an appropriate standard procedure to terminate such kinds of pregnancies. So today I am giving the proof of government document where such kind of a procedure has now been formally allowed. So it's not one-off case done by Dr. Nikhil Datar, but this is the reference that I am giving to you. Ultimately, the law had to change. Because I was fighting all alone and nobody was there with me, no medical organization came forward in open. In private, everybody kept on congratulating me for the efforts that I am making, but no medical body came in front to officially support me. It was one single-handed battle of 300 women and one doctor, crazy kind of a stuff. So obviously it was expected to take a long period of time, because one man convincing others and nobody else taking official stand or interest, you can't expect things to change so quickly. It took close to about 12 years. And ultimately, in Lok Sabha in 2020, the amended act was passed. In Rajya Sabha 2021, it was passed. In March, on the 25th of March, presidential assent was received. And on 24th of September 2021, the amended MTP Act is now officially passed and applicable to Indian context. And this is the Gazette of India, which says that the law has now been applied for its use. Now, what are the changes that have happened after the amended law? Now, there are some good news and there are some bad news. The good news, as we all know, is termination of pregnancy now can be done up to 24 weeks, but it can be done only for these 6 indications. And if you read these 6 indications, you will find that failure of contraception is not seen anywhere in this particular list. So it means that for the ground of failure of contraception, termination can still be done only up to 20 weeks and not up to 24 weeks. Up to 24 weeks, termination can be done for one of these conditions, one of these 6 conditions that we are talking about. So if you all want to take a photograph, you might want to take a photograph of this particular slide, because only for these 6 conditions, termination up to 24 weeks can be done. So that's a big good news. Second good news, now with the amended law, earlier on, up to 12 weeks, 1 doctor, and 12 to 20 weeks, 2 RMPs were necessary. Now up to 20 weeks, only 1 RMP is necessary. Between 20 to 24 weeks, 2 RMPs consent is necessary. So this is another good news that we have got. And the third good news is that now termination of pregnancy is possible even after 24 weeks for severe fetal abnormalities, but that can be done only by the permission from the medical board at the state. And I have written query over there, and I will talk about it a little later, that probably termination of pregnancy beyond 24 weeks can only be done in government setup. Please keep that question mark in your mind. I will address that question mark a little later if time permits. Lastly, previous MTP Act used to say that medical method of termination, that is giving MIFI and MISO combination, can be given only up to 7 weeks. But now the new or the amended law says that termination of pregnancy can be done by medical methods up to 9 weeks of pregnancy. Now, with some good news, I will try to point out some not so good news also. In this particular act, there is a new term, that is definition of termination of pregnancy, that has got added. This is added as section 2E. And please read the definition of termination of pregnancy. According to me, it's one of the silliest definitions that anybody can ever draft. Termination of pregnancy means a procedure to terminate the pregnancy by using medical and surgical method. Extremely silly, complete non-application of mine. Now my questions are: A, what do you mean by termination of pregnancy? What are you terminating? You are terminating pregnancy. What is pregnancy? Pregnancy is the state of the woman to bear the child in her womb. So any procedure that is done so that the lady does not bear the child in the womb fits into the definition of termination of pregnancy. Now, if suppose somebody interprets that even inducing labor to get the delivery done for whatever reasons maybe is also termination of pregnancy, am I wrong in defining it in this particular manner? Basically, termination of pregnancy word is a very misleading and confusing word. Ideally, that word should have been replaced by the word abortion, or the termination of pregnancy should have been defined clearly based on intention, that when you terminate someone's pregnancy by using medical and surgical method with the intent that you do not want that particular child to stay alive, or you want to hasten the death of that particular child, only and only then it will amount to a termination of pregnancy. Then it would have made some sense. Otherwise, every case of miscarriage can become termination of pregnancy. Every elective C-section can become termination of pregnancy. Every induction of labor can become termination of pregnancy. And hence, according to me, it is the silliest of definitions that one could have ever probably done. Second big trouble is that according to the new law, termination of pregnancy cannot be done beyond 24 weeks if it's a case of a minor rape survivor. Now, it's very funny that I have at least about 25 to 30 judgments from various high courts, including Supreme Court, where courts allowed termination of pregnancy for minor rape survivors even after 24 weeks of pregnancy. Now, if so many courts have allowed it, why is government trying to restrict it at 24 weeks? I don't have an answer to this. So on this ground, I would say that it's not a very great news. Thirdly, as and what I said earlier on, that this particular amendment talks about medical board, which will allow termination of pregnancy beyond 24 weeks. But if you see the constitution of the medical board, then the constitution is you have one gynecologist, one pediatrician, one radiologist, and few other associated specialists, maybe cardiologist, maybe neurologist, or whatever the case may be, as the board members who are expected to decide this issue. Now it is very funny. If you read the Medical Termination of Pregnancy Act, it says that there is a definition of registered medical practitioner, and under MTP Act, who is registered medical practitioner? Medical practitioner who is not only registered with medical council but having certain amount of qualification, experience in doing terminations of pregnancy. In short, by far and large, somebody having a degree or diploma qualification in obstetric gynecology is a registered medical practitioner under the law. Now, in this particular medical board, there is a pediatrician, there is a radiologist, and there is a neurologist, and maybe a cardiologist. None of these people have any experience / qualification under the law to be able to qualify as RMPs. Those who cannot qualify to be RMPs, how can they be sitting on the medical board to take the judgment or give the judgment or pass the judgment about termination of pregnancy? According to me, again, it's a complete piece of non-application of mind. I am not saying that we don't need cardiologists and radiologists and pediatricians and neurologists, because they are the ones who will give the correct information about the outcome of the baby to the gynecologist. But ultimately, it is the gynecologist who is able to understand and do the balancing act between the mother and the fetus and decide about the termination of pregnancy. So ideally, the framework should have been that there can be 1, 2, 3, 4, whatever number of gynecologists in this particular team. Other type of specialties could be able to assist these gynecologists to come to a conclusion. But decision has to happen from the gynecologist who fulfill the criteria of registered medical practitioner. Otherwise, I showed you that case of pediatrician. Tomorrow there will be one pediatrician who will say that I don't think Down syndrome is a serious abnormality, so no termination should be given. According to me, it's the biggest injustice that probably could be caused. And more interestingly, if at all such kind of a judgment comes from these medical boards, there is no scope of appeal against this particular order as far as the law is concerned. Can I know how much time I have got?
2 minutes more, sir.
Okay, great.
Thank you.
Last and the biggest problem that we are seeing is a new section that has got added, that is about confidentiality. The new section says that there will be a severe punishment for breach of confidentiality, which can extend up to imprisonment of up to 1 year if information is revealed to somebody except to the person authorized by law. And the word authorized by law has not been defined in the act. So my question is that today, if I have done MTP and if I have got certain papers or register or whatever is there, tomorrow if police comes, is he a person authorized by law for MTP? Tomorrow I get a raid from income tax office and they say, come on, show me your income expenditure papers and show me the receipts, in which they find a receipt of this woman. Will it be considered as a person authorized by law? Tomorrow, I have done an MTP of a person, of a woman, and we all know, all gynecologists know that theoretically MTP can be done only by the consent of the woman. Now, if her husband comes tomorrow and asks me, is he an authorized person by law? Can I give this information or I don't have to give the information? There is no definition of the person authorized by law. And if medical bodies do not stand up against this particular thing today, then there is no point in talking about things later on. I mean, on one hand, I'm extremely happy that the speaker before I spoke, he spoke of so many fallacies of PCP Act. But our trouble is that we only speak in conferences. We do not take it onto the road. And because we do not take it onto the road, we never are able to find a solution. We only do this activity of discussion with no solution. So again, it is my request with folded hands that medical organizations, please stand up, please get up from your slumber and please come onto the road, come into the court, shoulder to shoulder with me, and we will make the change happen today, right now. Right now is the time to challenge it when the new law has come. But if we decide to sleep and only do this business of discussions, then nothing is really going to change. And there are so many problems which have still been unresolved. Okay, now Form 1, Form 3, consent forms. Because of lack of time, I don't want to get into it. Probably at some other time, I would be able to say about it. Last and another very major brewing issue that I want to again bring it to you and again request people at IMA and other organizations to take up this issue, that all those fetuses which are born after a delayed or a late termination of pregnancy. Today, let us say that I terminate a pregnancy at 28 weeks. Let's say there is anencephaly with proper order and medical board and blah, 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 blah. Now the question is that how am I supposed to dispose of that particular body? Do I have a certification for disposal of an abortus? Answer is no. If I try to give it to biomedical waste, under biomedical waste, they will say it's weighing more than 500, we will not take it. So it means I will give a certificate of a stillborn. Now imagine that because of the amended law, say 10,000 legal terminations happen after 24 weeks, but the disposal is going to happen by giving severe preterm, death certificate, stillborn certificate. It means we are ourselves wrongly inflating the data of stillborns, of premature deaths, etc. And if tomorrow we are judged badly on various indicators saying that in India, the situation is so bad that the incidence of maternal fetal mortality is increasing, neonatal mortality and neonatal death is increasing, who is to be blamed for it? It is just this particular nonsensical kind of a thing that we have not addressed, and that's why we are going to face this kind of an issue. And these are challenges which we need to sort out right now. Ultimately, I just simply want to say that MTP after the amended law can be done after 20 weeks for serious abnormalities and rape survivors. Up to 24 weeks, it can definitely be done with the help of 2 gynecologists. Beyond 24 weeks, it needs to be done with the permission of the board. However, at this point of time, even the rules have been framed, but rules have not yet been applied. It's something saying something like this, that I have been given formal admission to the medical college, but medical college only doesn't get started. So theoretically, I don't start my journey as a student, although I'm technically a student. This is exactly where we are as far as MTP Act is concerned. So I would, I think, stop at this point of time. Thank you, ladies and gentlemen, for patient hearing. If there are any questions, I would like to take them right away, because I will not be able to wait till the end of the program to solve the questions. Thank you once again.
Sir, thank you very much. One of my most important question that we have very carefully we have listened to your lecture, but as the human error, as soon as we go and start our practice, we may forget. So what should all the practicing gynecologists and radiologists should take precaution to avoid this law breach?
You have to stick to the law, basically. If the law says that this is where you have to do, you have to do.
Now, what are the amendments? So, is there any booklet so that they can go and further polish their knowledge?
Madam, today you go to Google and
Yes.
you simply type MTP Amendment 2021.
Yes,
you
sir.
get a PDF of
No.
rules and the law.
No, not that. What precautions they have to take to avoid all these complications ahead?
See, MTP Act prima facie talks of what all things. Who are the people who can do MTP? So by far and large, gynecologists are the people who can do MTP. Non-gynecologists, except very few for early pregnancies, they are allowed to do. But by far and large, gynecologists should do. Every gynecologist should see to it only at registered centers, even if they are qualified. But if the center is not registered, then you cannot do MTP at their centers. And number 3, you have to be very clear with what indications you are doing and up to what weeks of pregnancy you are doing. If you are very clear on this, and then you do the right paperwork, consent form, form 1.
Filling of the form, yeah. Yes, sir.
Doc-
Filling of the form, submission of all those documents to the PMC or BMC, wherever corporation. So we have to keep a watch that we are doing all the things in a
Madam,
without
there is
any
no,
delay. Otherwise, there will be
there
a
is,
problem for the person, though they know, but
Doctor,
sometimes you forget that, oh, till 5th, I have to fill all these forms and I have to submit, but you have not submitted. Then you are at fault, isn't it?
Madam, there is no F form as far as MTP is concerned.
yes.
There is form C, which is consent
Yes.
form, and form 1,
Yeah.
form I, and MTP
Yeah.
registered in form 3. So these are the 3 things that you are supposed to do. This is what is the legal requirement. These are the only 3 things under MTP Act which you have to keep.
Yeah. Yes, sir.
Dr. Datar, sir, just a submission or a comment, I would say. It's a very, very valid point. I am a member on the MTP committee, local committee for the district as well as corporation for last many years. So the disposal part of it, the biomedical waste disposal, that is a very valid point. And then I've been actively involved with conducting some medical research also related to stillbirths in India, which is a real challenge. And then maybe we can have a subsequent discussions later on about how, what solution do we offer for such type of things. And maybe that is an addendum to all your efforts related to the amendments, which are really
For
very,
that, basically, one will require to have an amendment to the Birth and Death Registration Act, because today under Birth and Death Registration Act, there are only 2 classifications. One is birth and second is death. Birth is of 2 types. One is live born and second is stillborn. There is no entity called abortion or termination of pregnancy. Why? Answer is very simple. Birth and Death Registration Act was framed in 1969, even before MTP Act came into picture.
yes.
In 1969, there was no concept only of termination of pregnancy. So Birth and Death Registration Act needs to be amended so that a new certificate, additional certificate called termination of pregnancy disposal will come into the picture, which will officially solve all the problems.
Yes, through this forum, because this is a state level consultation meet, you can say, we will definitely forward and try to help you in all your efforts for the proposed amendments. Our appropriate authority from Pune city is also with us today, and maybe during the question answer section, we will definitely be talking to her also regarding to this particular issue. She's also looking after the births and deaths for the city. Actually, that is one good thing. So Pune model can work. If Pune model can work, be out, that could be a guideline for the further amendments. It's really.
Madam, I heard.
Before we conclude her session, Dr. Datar, good afternoon. I'm Dr. Meenakshi Deshpande. We were actually going to put these questions in your panel discussion. But now that you said that you want to go early, so just 2 questions are there from our side, because you have done so much research work on this MTP amendments. What is the definition of RMP? And there are 2 or 3 questions which have come up in the chat box also. So according to the court of law, who will be the RMP in this MTP amended act? Whether it will be a MBBS person, an MBBS person with training, or a MBBS person with OBGYN training?
Okay. So first and foremost, I want to say that there is no amendment to the definition of RMP with the new act. So definition of RMP is the same age-old definition of RMP, which was given in 1971 and rules of 1975. There is nothing new as far as RMP definition is concerned. Now, in 1975 amendment or rules, it is very clear that are the people who are to be called as RMP under MTP Act. First and foremost, they all have to be registered with the Maharashtra Medical Council as far as Maharashtra is concerned. BAMS, BHMS people are not supposed to be there at all because they are not members of Maharashtra Medical Council. I'm just making it very simple. I mean, not using the typical legal terms. So that is first. Now, the second question is about qualification and experience.
Training.
If we are talking about terminations, which have to be done in terminations, which are first trimester terminations, then a MBBS doctor just having experience not having any postgraduate qualification, degree or diploma, but just having adequate amount of experience, probably experience of doing 25 cases, preferably where he should be able to show his certificate of experience, then that such person can be considered as qualified registered medical practitioner only for the purpose of first trimester MTPs. When it comes to second trimester MTPs, you have to have compulsorily either qualification, that is DGO, MS, MD, DNB, or at least have one post of 6 months done in OBGYN, and again having the requisite certification and proof of the same, then that person is registered medical practitioner for the purpose of doing second trimester MTPs. So it means, if I have to put it in one line, then any doctor with minimum additional qualification in OBGYN / experience in OBGYN will be considered as registered medical practitioner for the purpose of doing MTP.
That will be for second trimester and from 20 to 24 weeks onwards.
Yes.
Up to 20 trimester, up to 24 weeks. That to be.
Even after that, I think they have to get a consultant, I mean, obstetrician only for taking the decision, medical board, and for carrying out the procedure.
Yes.
Sir, I have a question. Maybe will be discussed in the question answer forum also.
He's not there. He's not there in the question answer session.
That is why I'm asking him about his experience and opinion. It's regarding the old centers which were recognized up to 20 weeks and with the extension of 24 weeks. Now, whatever new registrations are coming up, they will be given the this thing approval up to 24 weeks, because this is what is done within the MTP committee at the state, at the district as well as the corporate. But what about the old ones? Do they need to reapply for the extension of the weeks of gestation? And secondly, in that case, is it a new registration which is required, or because it is all these registrations are non-transferable, right? So these type of day-to-day issues are faced by the registered centers.
So honest answer to that, honest answer to your question is I don't know.
Okay, sir.
Okay. The reason behind that is that if you look at the new form, okay, now the new form says you have to apply either up to 12 weeks or you have to apply up to 24 weeks. Right? Now, till now, applications were only up to 20 weeks. There was no 24 weeks business. So are we going to extend the old centers up to 20 weeks suo moto and automatically up to 24 weeks? Or are we going to say that you have to reapply once again for MTP center? Now that's an administrative issue which probably center or state government will have to take up at their level. And there is no answer to this question given as far as rules are concerned. Now today rules are there out in open, but they have not yet been applied at the moment of time. Now I will draw your attention to one more very interesting thing and see this is how the things happen, and that's why we need to stand up against it. If you look at this new form for application, it says that you have to decide whether you want to apply up to 12 weeks or you want to apply up to 24 weeks. What does that mean? You cannot apply for more than 24 weeks for a termination.
True.
So on one hand, government is saying, in between also I read somewhere some high level government of Maharashtra person, I don't know, from ministry said, no, we are going to allow big hospitals to conduct termination of pregnancy even after 24 weeks, after the state medical board's approval. But the question is that suppose today I am Jangir Hospital or, highest, best probable hospital, but not a government hospital. I don't have methodology to apply only primarily for terminating beyond 24 weeks. So it automatically indirectly means that the government, by doing this amendment, has triangulated termination beyond 24 weeks by saying that you only have to do it at government hospital. Because private people, however good setup they have, let's say today there is Breach Candy. Now Breach Candy is 100% more equipped than JJ Hospital, but Breach Candy cannot apply only for beyond 24 weeks termination.
Yes, sir. Maybe the earlier form, if you remember, sir, it was up to, there were only 2 columns as up to 12 weeks or 20 weeks. And that has been amended to 24. That's all.
That's what I'm saying, that it's such a non-application of mine. And lastly, that's why I want to say this, that I said that my case is still going on. And the reason my case is still going on is that I have filed a fresh challenge to the Termination of Pregnancy Act 2021 with all these points. And that is why my case is still alive. But again, same story, that when one single mad fellow goes, it takes a very long time to convince people. But when a lot of people go together, it becomes easy. But that is exactly where there is a problem. That there is no force behind what we are saying. And because everybody wants to talk in conferences, nobody wants to take up as a challenge and change the system. And that's why the things take very long period of time. So till then, if at all suppose this confusion kills somebody, not physically but mentally, then we only have to be blamed for it. No, because we only sat on it. We only did not resist it. As a
something, Dr. Dr. Vaijayanti, I think we'll go on to the next speaker now because we are over the time.
Thanking sir.
Dr. Nikhil Datar, we'll talk on this someday and we will come out with some good option for you.
That's
yes,
exactly
and, yes, absolutely. And lastly, since you have a very, very proactive governmental authority, if there are any such kinds of projects that you want to take up, I will be pro bono willing to kind of take it up, only to make it very clear to the government over there that any medical advance that is made has to be conducive to patients as well as their healthcare providers, and just and fair to both sides, and only then it is going to happen and work. And I'm very hopeful that the kind of positivity that you people have in Pune, especially government authorities, I'm sure something will come out of it and some good thing we'll be able to demonstrate in coming years to come.
Thank you.
Thank you, sir. Thank you so much. Thank you.
Thank you. And I will request now Dr. B.L. Deshmukh, our president, to felicitate you. Sir, it was a real nice lecture.
This is a bouquet for you, sir.
Yes, sir. I have received it.
Yes, sir. And this is the IMA Uparna.
Sir.
This is IMA Uparna.
Oh, okay. Thank you, sir. Sir, your bouquet I have received your bouquet only because of internet. The bouquet has changed a bit of color.
Good sense of humor, sir. Thank you. Thank you. Thank you. Thank you, sir. Thank you very much.
Thank you, sir.
Now, after listening to MTP Act and PNDT Act amendments, now we'll go to some different topic with Dr. Dilip Palke, sir, and we'll be speaking on ART bill, regulatory requirements for surrogacy and IVF. Mainly, it is useful for all gynecologists as well as all sonologists also. So I will introduce Dr. Dilip Palke. He's a consultant at Medipoint Hospital and Jupiter Hospital, Pune. He was the president, Pune Obstetrics and Gynecological Society in 2019 and 20. And he was a chairman, Ethics and Medical Legal Committee, FOXY, 2007 to 2010. And he's a founder, director, and advisory board member of Dr. Prax's telecommunication system. So with his short introduction, I think if I start introducing Dr. Dilip Palke, it will take me another 30 minutes. But with this short introduction, I will hand over to Dr. Dilip Palke. Okay, sir. Thank you. You can start your lecture, sir.
Yeah, thank you, Alka. Thank you for keeping it short. Am I audible?
Yes, sir.
Yeah, and I'll start sharing my screen. Just tell me whether my screen is seen or not.
Yes,
is it seen?
Yes, sir.
Yes.
Okay. So thank you for not introducing me for 30 minutes because I'm sure Alka is a good friend. तिने सगळे माझे काले चिट्टे open केले असते if she was going to talk on for 30 minutes. So let me get started, and thanks to Pune IMA, thanks to Vaijayanti, my friend, and Alka, and thanks to Dr. Naurange sir for giving me this opportunity. Dr. Naurange sir, I always tell that he's my mentor when it comes to anything that I speak on medico-legal aspects. And before I start, a disclaimer, I'm not a lawyer and I'm not an ART specialist. So if there are any ART specialists sitting in the audience, please at the end, don't put some googly questions on ART to me, because my knowledge is only about few legal aspects and not about ART. So the agenda today is we'll together try to understand the provisions, try to identify the pain points, then later on together dream of good rules and regulations to come, and eventually be knowledgeable about the regulatory requirements. And we will have a passing reference to Surrogacy Regulation Act 2021 if time permits, because though managing both the acts will be a little too difficult in a short period of time. The background is like this. On the 20th of December came the ART Regulation Act, which got notified. Then on the 25th of December came the Surrogacy Regulation Act. And on 25th of January 2022, these two acts were actually in force. But we are still waiting for the rules to come, for the regulations to come, and for the national and the state boards and the national registry and the appropriate authority to yet get formed. So this is what is the background. And as no sooner than this act was actually notified, the present day ART specialist had many things to be painful about. One thing is that they said commercial surrogacy khatam ho gaya. So abhi now surrogacy in our country is gone. Kuch bhi bacha nahi hai, because there is no more commercial surrogacy. Secondly, the oocyte donors can donate only once in lifetime, which means abhi donor cycles bhi khatam ho gaye. And they are yet not very sure about what to do, because the act is in force from the 25th of Jan. And what is it to be done and how to manage their ART from the 25th of January 2022 till actually the rules and regulations are going to be framed. So let's try to find out. First of all, let us start with some definitions in both the acts which need a little bit of clarity. When we talk about the definition of ART itself, then it says that it is a technique to obtain pregnancy by handling gametes and also transferring the gametes or embryo into the reproductive tract of a woman, which means now even IUI is going to be considered to be ART, which means if you were a center who was getting semen sample from outside and doing IUI in your clinic, then that you'll have to stop, or you'll have to register yourself as an ART center. So those who are doing IUI, please beware. Secondly, definition of ART bank. The act says it is for collection of gametes, storage of gametes and embryos, and supplying the same to the ART clinics or their patient, which means they are saying that the ART bank also should be like an IVF center where there is facility for stimulating, facility for ovum pickup and freezing of the oocyte. But when the act is defining the functions of ART bank, it merely says screening and provision of gamete donors, male or female, collection, screening and storage of semen only, which means when it comes to oocyte donor, the act is saying only do provision, no collection, no storage, provision of the donor. Semen donors, they say do provision of the donor, do collection and do storage also. So this is a little bit of confusion about the function of the ART Act, which has to be solved as the rules come. Another confusion with the banks is they say that the banks and the clinics they have mentioned should be of a different entity. Now, there have been various webinars in which this confusion was being floated when they said that it has to be of a different entity. Does it mean that it has to be owned by a different person? Does it mean that we cannot have a bank and an ART clinic in the same premise? Or can there be a ART bank or ART clinic owner be a part owner of a bank? So these are some of the questions that are still there. And as the appropriate authority will get will start actually implementing this act, the answers to these questions will come. And there has to be some case laws to get these answers also. Then again, ART service, which is there for Indians and for foreigners too. So this is one thing that everybody needs to understand, that we can do our IVF even for foreign couples. And they say that the commissioning couple is the one which is infertile, that is 1 year of unprotected coitus, who are married. A woman has to be between 21 and 50 and man has to be between 21 and 55, which means because the commissioning couple has to be essentially married, it means that ART is not available for live-in couples. This is going to be very unfair for live-in couples. So maybe some PIL or a writ petition will be needed for the live-in couples also to get a right to have their own children by ART. It is also available for women above 21 and up to the age of 50, which means an unmarried girl can opt for an ART provided she is between 21 and 50 years of age. But for surrogacy, there are some different criteria, and let's have a look at what the criteria are for surrogacy. Now, surrogacy is available for Indians and for people from Indian origin only. They cannot be foreigners technically. Even if they are foreigners, they need to have something to say that they are from Indian origin. Intending couple for surrogacy has to be essentially married. Wife has to be between 23 and 50, and the husband has to be between 26 and 55 on the day of surrogacy and with no surviving child, while the intending woman has to be previously married and now divorced or widowed and aged between 35 and 45 with no surviving child, which means a female who is previously married, now divorced, can opt for surrogacy, but a man cannot avail for surrogacy and become a single father in our country, which is going to be very unfair for men and maybe for men. And that's why maybe a PIL or a writ may be needed for the favor of those men who want to become single father with the help of surrogacy. Definition of embryologist tells us that the embryologist is defined as somebody who's got a PG degree in medical, which means either an MD or a DGO or something, or an MS, or a PhD in embryology with 2 years of experience. Now, if this is going to be the definition, then most of the embryologists will be out of business. So I think a lot of advocacy will be needed here to see to it that this definition of embryologist is changed. Fertility prevention, preservation. Now imagine a girl who's less than 21 years of age and wants to preserve her oocyte because she wants to get married late, or because she has got some cancer needing treatment, or because of some cancer she is supposed to undergo a total abdominal hysterectomy. Now, and she wants to store her gametes for surrogacy. The Surrogacy Act says that storage of gametes is not allowed. So it's going to be unfair for this girl. So this needs to be addressed. Also, imagine a boy less than 21 years of age wanting to preserve his sperm because of some testicular problem. The age limit and the insistence for marriage will come in his or her way of ART, because the ART preamble itself tells us that fertility prevention is within the ambit of the ART Act. So advocacy is needed for removing the clause of age and marriage, especially for fertility prevention. Now, the Act talks about formation of the national and the state board, the surrogacy board, the national registry, the appropriate authority. And for those who are interested, I mean, this is a very crammed up slide. For those who are interested, I can share it to you. It is not for us clinicians to understand that, but it is for the lawyers to go through it, because then if there is a case against you, they will go through this slide and find out whether the appropriate authority was properly formed, whether the national board was properly formed or not. But you have to remember that the government officials, which is the appropriate authority or the board or the registry, are protected for action taken in good faith for searching and seizing as per the criminal procedure code. So all the appropriate authorities who are attending here would know that they are protected if they have taken any action in good faith while they come here in our center for search or seize. Now, registration simple as you register yourself for a PCP thing, where there is an application form with fee, with a proper format and fee. The appropriate authority is supposed to grant the license within 30 days, and they have got 7 more days to spare. But if they delayed for more than 7 days, more than 30 days, the next week they have to give reasons why there was a delay. And if they reject it, they have to give reasons and give chance to the center to be heard. And then we are supposed to keep that that certificate in a conspicuous place. Now, this conspicuous is also something, because we have experienced it in PCP and AT. There is no proper definition of what place is a conspicuous place. So again, this is going to be a problem with this act also. And of course, you have to renew it after every 5 years. And you have to remember here, when it comes to surrogacy center, that license has to be renewed every 3 years. While it comes to ART center, you have to renew it every 5 years. Again, appeal against the rejection, suspension or cancellation of license, same, within 30 days to the state or central government, as the case may be. Simple. These things are simple. But what is important and what is new is what you have to understand from this slide. the important general duties of a clinic or a bank. Now, simple things like checking the eligibility, taking consent form, getting the consent form filled, doing counseling, grievance cell, discharge summaries, and all that is going to come in form of formats in the rules that are going to come. So that will be easy for us to understand. But you have to understand that donor gametes you will have to get only from the banks. You cannot get it in your own center. You're supposed to maintain the confidentiality of the commissioning couple, the commissioning woman, and the donor and their treatment. And you are supposed to give this information only to the National Registry, which means now there will be no advertisements with patient's identity. You cannot say that this so and so patient, I got my fertility treatment done at this center. So that is not going to be allowed. You have to keep the name of the patient confidential. 1 year insurance for oocyte donor to cover complications. Now, on one hand, they say that the donor's name has to be confidential. And on the other hand, they say that you have to give an insurance, and who pays for the insurance? If the commissioning couple or the commissioning woman has to pay, then the confidentiality between the commissioning couple or woman and the donor is not going to be maintained. So ideally, I think the payment will have to be made by the bank, and the commissioning couple or the commissioning woman will make the payment to the bank. Of course, withdrawal of consent by anyone from the commissioning couple or women before transfer of gamete or embryo is allowed. They can withdraw the consent anytime. This is important. Cryopreserve gamete or embryo, zygote, ovarian tissue, and use by spouse posthumously after death. This you can do only if there is consent taken before the death of the commissioning couple, anybody from the commissioning couple or the commissioning woman, and maximum you can actually cryopreserve for only 10 years. But there are certain questions requiring clarity. Whether a commissioning couple or commissioning woman can give consent for the embryo to be given away for donation for use on any other commissioning couple or commissioning woman. Now, this is not allowed. This we used to do before. So now no more embryo banking. That is not allowed. But if the commissioning couple and the commissioning woman needs a donor embryo, what they have to do is not take it from an embryo bank, but they have to take a donor oocyte. They have to take a donor sperm. So they will need 2 donors and create an embryo for themselves for personal use. So this is what the new act says. Of course, record keeping in a prescribed format to be kept for 10 years and till final disposal of court case or till the center closes. And after everything is done, the record has to be sent to the National Registry. So the record keeping for ART is for 10 years. And for surrogacy, it is for 25 years, that you have to remember. Now, duties with respect to techniques on gametes and embryos. How to retrieve egg? The government is going to tell us in the regulation. Now, this is very unfair. How we should retrieve the eggs, I don't think this is one thing that the government should be telling us, but this is what the act says. Not more than 3 embryos or oocyte to be transferred inside the uterus. This is what the act tells us. And in case of surrogacy, the number of embryos to be transferred is yet not told, but they are going to tell us about that in the regulation. So this is one thing, and following is not allowed. And this is very obvious. More than one man's sperm or more than one woman's gamete per cycle, every cycle is not allowed. So mixing of semen is not allowed. Embryo splitting is not allowed, and oocyte from fetus cannot be used. So these are the certain things which are not allowed from now on. PGD on embryo only for known pre-existing heritable disease or genetic disease in one or both of parents, and the affected embryo has to be donated to approved research lab only. Sex selection, no XY fractioning of sperm, no sex selective prescription, no sex determination of embryo except to diagnose, prevent, or treat sex-linked disorders. So this is one thing which is very important that you have to remember. Now, criteria for donors are like this. The age of the semen donor has to be between 21 and 55, both inclusive, and that of the oocyte donor has to be 23 and 35, both inclusive. A medical examination in the prescribed format has to be done. Confidentiality, as I told you, 1 donor oocyte or 1 donor sperm to only 1 commissioning couple or commissioning woman, which means no sharing. And by the way of Aadhaar linkage, you have to ensure that the oocyte donor donates only once in lifetime. Now, though such is not mentioned for sperm donor, however, if it has to be used only, the sperm has to be used only for 1 commissioning couple or one commissioning woman, it also means that even the sperm donor is supposed to donate only once in lifetime. But you have to, this is going to be something which is going to be very difficult, and we are going to find it difficult to get the oocyte, enough number of oocyte donors and sperm donors, especially because of this particular criteria for donors. That's which you have to remember. And another important thing which needs a lot of advocacy is that the Act says that you can retrieve maximum 7 oocytes from the donor. Now, this is going to be very difficult for the ART consultant, because you cannot predict how many ovum oocytes are going to be stimulated when you gave a stimulation. The only thing that they could have mentioned is do minimal stimulation. But one stimulation, more than 7 oocytes can get stimulated. And sometimes, because more oocytes are stimulated, you may need to do aspiration to prevent ovarian hyperstimulation. So a suggestion was mentioned during one of the webinars that instead of saying retrieve, you should say use only 7 and the unused to be called as surplus. This unused oocyte has to be sent back to the bank for storage, and for use on the same recipient in other cycle, it has to be sent back to the clinic and or give to the research laboratory. So this is something that is going to cause a lot of problem to the to clinics to send it back and to get it back again. So these are some of the problems that are there in the Act. Now, storage of gametes, embryo or tissue, the standards are going to be mentioned in the rules, maximum for 10 years. And the Act mentioned that the storage is for 10 years is for donor gametes and embryos. So which means my question is, if the gamete or the embryo is for self, can it be stored for more than 10 years? This is one thing that is there in my mind, but I think that is going to get cleared when the appropriate authorities are trained for it. After 10 years, of course, with the consent of the commissioning couple or the women, you can allow it to perish or you can donate it to the authorized research labs. Important, sale, transfer or use of gametes or zygotes or embryo or part or information of it is not allowed unless for self-use with permission of the board. So only when you're transferring the gametes from, say, one city to another city, because the commissioning couple is going from that, getting transferred from one city to another city, that you can do, but only with the permission of the board. But you cannot sell or transfer the gametes. The unanswered question is, what about compensating the oocyte donor for that time that she has given for oocyte donation? Now, will whatever compensation that we are going to give her, will that be counted as sale of her oocyte? That is one thing that has to be addressed yet till the rules come. Now, research outside India is not allowed, but research within India in a prescribed manner only to the authorized research laboratory. Right of the unborn, of the child born through ART, of course, it is deemed to be the biological child of the commissioning couple or the woman with all the legal rights, and the donor has to relinquish all the parental rights of the child. Penalties in case of contravention. So this is one thing that that everybody wants to understand, and I've tried to capture it in one slide. Now, the Section 32 says that no advertisement in any manner about sex selective ART, because people, after reading this, many of the ART centers said that now we cannot even advertise our ART centers. You can advertise. The only thing is you're not supposed to advertise saying that you are doing sex selective ARTs, because if you do that, then there is a punishment of 10 to 25 lakhs or 10 to 10 years or both, which means this or is very important. You may get away by only giving 10 to 25 lakhs and you may not be imprisoned at all. But when it comes to surrogacy, there is no or in any of the penalties of the surrogacy. If we have time, we'll go to the Surrogacy Act. So there it is and. So we are very lucky when it comes to ART, it is either giving some compensation or getting imprisoned or both. Section 33 is all about you abandoning the child or disowning the child or exploiting the child. Exploitation is not actually defined, but this is what they say. Sale of embryo or gamete via any agency, importing or causing to import embryo or gamete, exploiting the commissioning couple or the commissioning woman or the donor, ET in a male, sell for research, using of tout to get or purchase donors. For that, 5 to 10 lakhs for first offense and 10 to 20 lakhs and imprisonment for 3 to 8 years if subsequently you do this offense. And for contraventions with no provided penalty, again the same as what is the punishment for section 33. You have to remember that it is all cognizable but bailable. In Surrogacy Act, it is non-bailable. Bailable means that you can get bail from the police station itself. So that is one thing good about any contravention of the ART Act. It is cognizable offense, but the cognizance can be taken only by judicial magistrate first class on complaint by board or the appropriate authority. And liability of the executive head or the officer of the clinic or bank. So if the bank is owned by somebody who's not an ART specialist, and what if the ART specialist is contravening the provisions of the Act, will the owner be also responsible for it? He will be responsible unless he proves that he has done all the due diligence in the center, in the bank or the clinic, and he was unaware of whatever contravention that particular ART specialist or the gynecologist or the geneticist was doing there. So the owners of the ART clinics have to be very careful about the kind of people that they are going to employ in their center. Now, we are waiting for all these rules that are going to come from the government of India. These documents are yet to come, and we are waiting for the national board to make all the regulations. This act is in addition to and not in derogation of other acts. So the MTP Act, the PNDT Act, and the Clinical Establishment Act still stays. But at the end, when I gave you this presentation, you must be feeling there are so many problems. Can anything be done now, or is it too late? Like Nikhil was saying, unless we get up and we fight now, it is going to be too late. It will be too late as it happened with PCP Act, and then it will be very difficult for us to get things amended. So what is it that we can do? There are two provisions we can take use of. One provision is that the rules and regulations that are going to be made now will be put before the house, before both the house, the Lok Sabha and the Rajya Sabha, for 30 days, maybe 30 total days. I mean, in one session or more than one session. But here is we've gotten scope for advocacy with the members of both the house. So if we can do advocacy with the members and tell them about the problem, maybe in the rules and regulations something might change. Similarly, the government of India can, the Act says that they can remove some difficulties within the Act if they find that there are some difficulties in the Act in the next 3 years. So we've got 3 years of time for doing advocacy with the members of both the house to get it approved from both the houses, and the difficulties in the Act can be removed. So I appeal to all the Foxies, the SR office bearers, the IMA, to take advantage of these two provisions in the Act and try to see that whether we can do some advocacy to remove the problems within the Act. But then advocacy with this government is really a hard nut to crack, and I understand that it is going to be very difficult. So at this moment of time, let us wait for the rules and regulations to come, wait for the orders to remove the difficulty, make an attempt to make a difference through advocacy, and follow the Act in letter and spirit till such time. But the question again remains, after 25th of Jan, till the rules and regulations are framed, what do we do? How do we practice? So for them, these are the 3 points. If the oocyte donor was stimulated before the 25th of Jan, then you could complete the cycle in the next month. So you had this month of March, maybe month of February, maybe, to do the needful for you. But now that month has also gone. So this particular point is no more valid now, because now you are in the month of March. But if the donor oocyte or gamete was stored before the 25th of Jan, now technically it is the property of the commissioning couple or the commissioning woman. So technically we should be allowed to use it even now, even when the Act, after 25th Act, the new Act is actually now active. But again, the law may specify something against it, and there has to be a case law to support it. So I will not recommend you to do that, even if you have stored the gamete before 25th of Jan. After 25th of Jan, you must follow as much the Act as you can. So which means so many things. One is whatever I mentioned about the age limit, you will have to follow. Oocyte donation once in lifetime, you will have to follow. But then you will ask me, how will I come to know whether this particular person who has come to me now, whether she has donated before or not? How will I come to know? The least you can do is take an affidavit, till the Aadhaar linkage is done. Take an affidavit from her saying that I am doing it for the first time. The next point is insurance for donors. Now, till such time that the insurance is actually valid and still the IRDA tells us about what amount and how, take an affidavit from the commissioning couple or the commissioning woman that she will give the money and she will see to it that all the treatment for the donor will be done in case there is some problem during the oocyte retrieval. Now they say no touts or agents. So recruit the donor directly and perform all the duties of the bank as mentioned till the banks are formed. Now, when it comes to surrogacy, contract between the intending couple and the intending women and surrogate, whenever you're making this contract, till such time that the rules are framed, confirm that there is no monetary compensation mentioned in that particular contract while you're doing surrogacy now, till the rules and regulations of surrogacy are maintained. So this is what is there about the ART Act. And if you have time for Surrogacy Regulation Act, I can finish it off in maybe 2 or 3 slides. So do you have time, Alka, for that?
Yes, Dr. Dilip.
Yeah. So I'll just try to cover Surrogacy Act so that you can get a very brief idea of what this act is. Now, surrogacy, they say, is no commercial surrogacy, only altruistic surrogacy. म्हणजे पैसे घेणं allowed नहीं है. And the only 3 headings under which you can give money to a surrogate. One is the medical expenses. Number 2 is the insurance coverage. Now they say insurance coverage for a surrogacy for 36 months, which means 3 years. And any such which will be prescribed in the rule. So that what is prescribed in the rule has not yet come, but that will come later. So you have to understand that surrogacy, no commercial surrogacy is going to be allowed anymore now. Prerequisites, a lot of paperwork is going to be there when it comes to surrogacy. One thing is you'll need to have an essentiality certificate by the appropriate authority to the intending couple or woman. And this essentiality certificate will be given if they have a medical indication certified by a board. They have something coming from the judicial magistrate first cry order of parentage of the child, of the child born through a surrogate, whatever is going to be the parentage and the custody is going to be with the intending couple, and a 36 months insurance coverage for the surrogate. This will give you the essentiality certificate to the intending couple. The eligibility certificate for the surrogate, she has to be willing, not known necessarily, but she has to be willing. It cannot be a relative. जसं organ donation मध्ये relative लागतं तसं इथे तसं नाहीये. A willing woman, she has to be married, she has to have her own child, she has to be between 25 and 35, she has to be a surrogate only once, and that will be actually judged by the Aadhaar linkage. She cannot use her own oocytes. Medical and psychological certificate will have to be given to her. Eligibility certificate by appropriate authority to the intending couple. The intending couple has to be from Indian origin, can be from outside India, but has to have Indian origin certificate. They have to be married. The wife has to be between 23 and 50. The man has to be between 26 and 55. No surviving child. Certified by the board, not likely to, that these are not likely to bear a challenge child. And the intending woman has to be between 35 and 45. Previously married, now widowed or divorced. So this is about the eligibility. Registration, of course, is compulsory. Again, it is the same as the ART Act. Only thing that they can grant the registration within 90 days, and the validity is for 3 years. No advertisement to search for, to induce a surrogate, to convey willingness that to be a surrogate, or to promote commercial surrogacy. So this is not allowed. MTP example, in case of a malformed fetus, only with the consent of the surrogate mother and authorization by the appropriate authority, and as per MTP Act. Storage of gametes or embryo for surrogacy to be done later on is banned unless it is needed for sperm bank or IVF or medical research. Records to be kept for 25 years or till final disposal in the court case. Existing surrogate mother to be taken care of for the next 10 months, that is 25th of January, 10 months from the 25th of January 2022, because anybody who may have become surrogate after by 25th of January, when the law was enforced, they will need to deliver. So they have kept this 9 months period for that. Punishments, of course, you have to understand that advertisement is not only advertisement, but a notice, a circular, label, wrapper, document through internet or any other media in electronic or print. So they have included everything in advertisement. So you just cannot get away saying that was not advertisement. Anything that you can think of in advertising, even on the social media, will be considered as advertisement. Again, these are the different headings under which the punishment is there. If anybody is interested in starting a surrogacy clinic, they'll have to understand what it is. I will thank you for a patient listening, and I'll wait till the questions come from the audience during the interaction. This is a new act, ART and the Surrogacy Act, and I don't think many of us will be aware of this act. For those who are infertility specialists, I think they should be, because MTP is one thing that everybody does. Surrogacy and ART is something that not many people do. So thank you very much for a patient listening, and thank you, Alka, for giving me that extra time for surrogacy.
Yes, sir. And Dr. Walke, many questions will be there, but I think we will discuss them in open forum, okay, which is more important and more interactive session.
Right.
So will it be okay for you?
Yeah, I'll wait. I'm in Bombay. I'm not doing anything.
Yes. Okay, sir. So we'll be waiting. Thank you very much. And I will request our president, Dr. B.L. Deshmukh, to felicitate you.
Thank you very much. Thank you.
Yes. And this is the IMA Uparna. So come to IMA Pune.
No, I'll come and I'll take it.
Okay. Thank you very much.
Thank you.
छान मस्त झालं सगळं अगदी point to point. So thank you very much.
Thank you.
Welcome, Dr. Kalpana Balivanta, madam. We missed you in our inauguration function. As everyone knows that this workshop.
Unmute karo.
Yes, madam, you are unmute. Yes, we can hear you. So this MTP PNDT workshop is by IMA Maharashtra State in association with Pune Municipal Corporation Health Department. So our Dr. Kalpana Balivanta madam, who is the Assistant Medical Officer of Health Department, Pune Municipal Corporation, and Dr. Ashish Bharti, who is the Chief Medical Officer of Health Department, Pune Municipal Corporation, has helped us a lot in arranging all this, all the lectures, and with their good support, we have taken this workshop. So I will shortly introduce Dr. Kalpana Balivanta madam. She is a graduated and post-graduation in DPH from Mumbai University, and MD Preventive Medicine in 1997 from Pune University, and she has worked in Talegaon. Then she was from 1998 she joined Pune Municipal Corporation as a resident medical officer. Then she was a ward medical officer. Then in H1N1 pandemic control, she was there from 2009 to 2010, and she has worked in other departments like reproductive child health program, chief immunization officer of PMC, chief insect-borne diseases control program, and in COVID pandemic, she was to look after COVID positive dead body management, information, education, and communication about preventive measures, and nodal officer of CCC. At present, she is the Assistant Medical Officer of Health and Appropriate Authority of PCP PMC. And she is in charge of Bogus Doctor Shodh Mohim program, and she is in charge of crematorium and burial grounds of PMC. So over to Dr. Kalpana Balivanta madam.
Thank you very much.
Unmute
केलं. ऐकायला येत आहे? Am I audible?
Yes, madam.
Thank you very much. First of all, I will thank all
Yes,
IMA
madam.
IMA office and I had prepared.
स्क्रीन शेअर करणार आहे का तुम्ही talk?
Actually, माझं प्रेझेंटेशन काहीच नाहीये म्हणजे माझं होतं प्रेझेंटेशन. I had a presentation, but after listening to all presentations, now there is nothing I can tell in my presentation. So,
Madam, but your topic is very important: legal and regulatory compliance of MTP Pcp Act.
Yes.
Proper authority to tell us.
Yes, I'm going to tell, but the presentation doesn't have all those components. Those components I had incorporated in a presentation. They were all presented very well from the first speaker till the last speaker.
Yes.
So I don't have a presentation. I'll just talk if it is okay.
Okay, madam. It is okay. Yes, madam.
Now, first of all, I will come to the first presentation that was by Dr. Viren Kulkarni. In that presentation, he has highlighted a few issues regarding, first of all, why PCP Act came into force, why there was a need of an act. So first thing is, as we all know, social stigma of having a daughter, preference to a boy is the only reason why we are, and the gender bias, why we are, all couples are on to having at least one son. That is the craze, I would say. So first of all, this social cause has led to preference to having a son. And third reason is only doctors can know what is the sex of a baby. By genetic methods, by now recently NIPT technique, or by sonography, only doctors can know the gender of the baby. So the law is executed or implemented, I would say, in a strict manner against doctor. This is the, I would say, myth in doctors, private practitioners, that this is against them. But I would say it is not against them. It is against the social evil of not having a daughter. So we both are on the same side. First of all, let me clear this. Administration, corporation, or legal body and private practitioners both are on the same side to stop this evil, social evil of gender bias. So if we take this as a theme, we say there are three sides. One side is your side, one side is my side, and one side is of a truth. So the same applies here. One side is your side. Yes, I know all the doctors are harassed because of the law and strict implementation of the law. And we are also harassed in a way by asking for so many things. But the final outcome of this law, intention of this law, is to stop feticide, female feticide. So first of all, please don't take this law as against all doctors. We all are together with each other. Secondly, for these unintentional minor mistakes. Now, these all words I will specifically stress on. Unintentional. Now, intentionally, nobody, very few people, they commit mistakes. Intentionally, they do something. But like Dr. Viren in his presentation, he showed that most of the time, those who are real culprits, they have all records very well maintained, and we don't have any point to note that this particular thing is not there. So only intention of not keeping records or making minor mistakes is not identified by law in all the terms which are explained in a legal act or bare act. Secondly, minor mistake. Now, what will you call a minor mistake? Now, what mistakes we come across in our regular inspections by our doctors and by representatives is, first of all, Form F are not signed by the sonologist. Whoever performs the sonography, they forget to sign the forms, or I don't know why they don't sign the forms. So not signing the form is a very big crime in the view of the law. When you don't sign the form, it means you don't agree with the form act of that sonography which is done. The same form F is uploaded online, so there is a mismatch of count. For online report, you have, for example, 325 sonographies, and hard copies, 2 forms are not having signature of a doctor. Now, this doesn't tell us who performed these 2 sonographies, which are uploaded on Form F by a particular registered doctor's login ID password, and which hard copies are not signed by that doctor. So according to law, this is not a minor mistake. First of all, let me clear this. Secondly, second minor mistake we come across is not filling the detailed address and information, obstetric history, information, address of the woman who is undergoing sonography. Each and every small part of this form needs to be filled with very, very care and responsibility. Not mentioning her obstetric history is hiding some of her obstetric history. Not writing the proper address means you don't want to reveal her identity by her address, which we may cross-check if we want to in some suspicion cases. So everything in that Form F, I agree. Less than 12 weeks, you cannot do sex determination. Nobody can do sex determination by sonography. Less than 12 weeks. Still, that form needs to be filled by the sonologist. Like now, I have been listening to the presentations all through all the 3 presentations very carefully. Because when law was made, definitely I think the medical representation was very, very less, or maybe I don't know why it was not properly presented, that what all things, medical, technical things should have been forwarded to the authority which actually makes these laws and acts. Because technically, less than 12 weeks, you cannot do sonography. You cannot detect sex by sonography. But still, you have to fill the Form F. And if that Form F is not filled properly, the law will catch hold of you. Now, this is a very big thing which should have been propagated, which should have been forwarded very, very actively. Like Dr. Datar said, stand up and come on the road. Even I agree for that. All medical terms and medical factors, still there is no, it's not the time has gone. Doctor said the time, it's too late for PCP. No, there is never too late. Still we have time to fight for these few technical points by which we can have some release, you also and us also, for these minor mistakes. Third minor mistake is not filling the Form F. Most of the time, now this is not a minor mistake, this is a very big mistake. But still, some of the doctors, they convey this thing that, okay, Form F was not filled because she just came and she was just having some inquiry, she's doing inquiry. These are my actual experiences. This is not out of my mind. This is our experiences, at least mine for last 4 years, that doctors do tell us such reasons, that she just came in and she was just doing a formal inquiry, a casual inquiry. So we didn't fill the form. But if you are giving her full information, even verbally, I think you should insist her to filling the form, because most of our decoy cases, what we have done, they are on that, the same ground. For inquiry, she came and she came out of the clinic and she has all the information regarding sonography and everything. And then she was planning to come back for sonography in an hour. She said, in an hour, I will come back. And before that, one of the unregistered doctor had already showed her how the baby looks. So that decoy case we did on one of the hospital. So these are experiences. Actually, I'm sharing my experiences. So please, these all conditions of mistakes, minor mistakes, there is nothing minor or major in this particular act, PCP&DT. Definitely the act is to stop sex determination by sonography and all other related techniques. And sex determination, as Dr. Viren Kulkarni very rightly said, by decoy case, by doing an active decoy case of SD, sex determination, only we can prove guilty the doctor, that the doctor has done sex determination. But for this, it is not possible only from our efforts. We need efforts from all doctors, radiologists, gynecologists, all doctors for this decoy and to prove those who are real culprits in this. Nobody knows who are real culprits in this. Those who are doing now, if I would like to share few stories, just one link we have recently got, that there are some code words and auto rickshaws and some vehicles, private vehicles are Ola, Uber, they are designated by doctors and these full racket, that if you use particular code word, they take you to those hospitals where SD is done and abortion is also followed by that, and which never comes to anybody's open, they never get open. So such people, see, evils are always there in the society. They are working on how to do all bad things. But if lot number of good people, same like-minded people come together, and if we all think and we all plan to fight against these culprits, then definitely good people, and most of the doctors are good. I can confidently say that in Pune city, at least, I don't think in Pune city we are having any SD done. All radiologists and sonologists and whoever is doing using these techniques for diagnosing all genetic diseases and everything for the purpose sonography is used. They are not misusing it, but definitely some of the administrative aspects all have to take care properly, and you have to be like I always compare this act with the Income Tax Act. We never make a mistake of single zero in income tax returns or while we submit our income tax certificate to the government. Not a single zero, because that zero is going to make a hell of a difference. My 1 lakh income can become 10 lakh. So similarly, please do take care. Even we don't like to go ahead with such cases. Now recently, 20th January to 20th of February, we had a special drive of inspection of these MTP centers and PCP&DT registered centers. But still we found out 35 defaulters. And all those defaulters were having the same type of mistakes. The online Form F number and the hard copies were not matching. Not signed by the doctors who are performing sonography. Not filled the information properly. So all these I would not say crimes, but all these defaults are definitely punishable. But definitely the punishment is not very severe, but it is going to be forwarded to us by a state government, because they had directed us for this special drive. So please, minor mistakes, don't consider them minor unless we come together and fight and really take out the bad evils from the society, the real culprits in the society. Nobody will be relieved of PCP&DT Act strict norms and regulations. Now for renewation of center as per Act, it has to be submitted 1 month prior to expiry of the date of registration. Still, we feel a lot of problems. Still, doctors, so many center holders, they are not, they are having some issues with their some contract of the rent contract, or some doctor appointment, or some one or the other reason for which they delay this. And if they delay even by 1 day, it is not considered, it is not accepted. You have to give it 1 month prior to your date of expiry of the registration date time. So please do it within time as per the Act, because all these small things are also mentioned in Act with a proper number. So we cannot violate them. Yes, definitely we can do some flexible considerations, and we can, but even that has some limit. Still, most of the centers, they are not aware of the legal implications, and then they keep on requesting, no, please take, just 2 days, Saturday, Sunday it was closed. Please don't make us in an embarrassing situation again and again. And please submit your renewation before 1 month of your expiry of your date of your registration. Third, the most suffered part is monthly report. Monthly report by Act, like I said, every small action, submitting the report, renewation time, everything is been mentioned as a clause. There is a clause in an Act. By this clause, you have to do this. By this clause, you have to do this. So please follow them. They are not in our hand to manipulate. Monthly report has to come before 5th of every month. If there are 3 working days, please do submit it. Most of the time when there are holidays, after Sunday, there's a Monday holiday, or that time we do keep our office open for Saturday, at least for half day, so that you don't have a 3 days gap for submitting the reports. But still, these things are for us to follow very, very scrupulously. We cannot manipulate there. So I need cooperation and support from your side regarding this. These are the common problems what we are facing while having a implementation of this PCP Act. So these problems should be taken on a very high priority at your level, all registered centers level, so that they just don't happen. There are some centers, I will not take their names, they're actually good. For the years, they have not stopped sending a report on the 2nd of every month. They have not stopped. If it is a holiday, they will submit on the 1st or 3rd, but they have never defaulted this particular issue of submitting the report. And this special drive is only to find out common problems defaulters. It is not to find out sex determinating centers. It is to see whether all rules in Act are followed properly by all centers or not. We were given challenge of examining 630 centers within 1 month, means almost 20, not more than 22 days, working days. Our team was really running around all the centers. But we have completed, we have on to completion of the task on Monday. 4 or 5 days, we asked for more this thing. And we have given 39 notices to those centers who have defaulted, they found defaulters in this particular special drive. So please, till we change, we appeal to the government, we appeal to the appropriate those authorities for change in these rules or some flexibility or some graded punishments in this violation of act. Till that time, we are going to call it violation of act. Now, it's a very big word. Violation is a very big word, but still we have to use it because it is mentioned by club. So it's my humble request to all, please don't overrule these 4 or 5 things. First, monthly report within time, before 5th of every month, renovation of your center 1 month prior to expiry. Third thing is signature of performer, medical registered doctor on every Form F without fail, because online software, sometimes there is some issues with the software. So online Form F, we might neglect if it is not filled online, because most of the time there are some issues for Form F. But hard copy is the thing to show that everything is working very fine. So please don't miss that. And lastly, most important, the address, full name, address, and obstetric history of that woman who is coming for the obstetric sonography. These 4 points are very, very important. 5th point is pertaining to your registration, place registration. This is the unique act or law, I would say, which is having all 3 parts of the system to be registered. One is man, the person who is performing. Second is the machine. So registered companies only can sell the sonography machines. And third, the place. Now the place issue is very, very serious. It should be taken very seriously, because most of the centers, they are not having completion certificate. They are not having proper documents of their place which they purchase or they rent out. And if the place is not clear title, then it is very difficult for us to follow the rules to register the place. So please, it is not in case of MTP Act, because I am member of MTP committee also. For MTP, we register the place. The doctors might change. Gynecologist there, whoever is registered initially, they keep on changing. They can tell us, okay, instead of Badiwan, somebody else is there. But place is registered. Not in case of PCP Act. PCP Act registered all 3 aspects of the act. So please do take care while taking a place where you are going to start your sonography clinic, because unless the place is clear title, it is very difficult from us to register that place at the sonography center. These important aspects, legal implications, I would say more than that, the day-to-day problems what you are also facing and we are also having regarding registration of the machine, transfer of machine. Then there are certain issues like people donate machines. So if we are getting the donation from outside Pune, please do take NOC from the appropriate authority of that particular local administration. There are some cases who directly get the donation from, say, out of Maharashtra, out of Pune, and then there is an issue of NOC from that particular authority. Ideally, you should take a NOC from that authority first to transfer the machine to the second authority, then apply it to the new authority, take NOC from them, registration from them, and then only shift the machine from outside limit, PMC limit, to the inside. All these things are not followed. Most of the time, they just do the formality of either donating machine to outside Pune without our permission, or they accept the donations from outside or purchase the machine from outside Pune limit from a center without our NOC or that NOC of that particular appropriate authority of that particular local administration. Now, both these conditions are very serious. Machine will be sealed. Serious action may be taken against such center holder. So please don't indulge in such type of, as per my knowledge, at least, we have made all things very fast, express. We don't take much time. Even the meeting is not up to, we don't wait till 2 months. We take meeting after completion of 30 days and before 60 days. So we try to understand your issues also. You invest a lot of money in that place, the machine registration. So we are also very happy to give it to you fast. But if you do it in time, if you give us time, proper time, we will do it very fast, and we'll try not to have any sort of problem for registration to you. But all this documentation and sequence of documentation should be in a proper way and timely done. Lastly, in this PCP issue, don't indulge political leaders or senior IAS officers or influential people. Please don't do this. My number is on the website. I think it's almost 3 years I have completed, and almost everyone has my name, my number and my name. Please do talk to me directly. Come to meet me. We will sort out the issue. Finally, it has to be done within legal framework. Appropriate authority cannot violate or cannot change the framework. The Act has a very compact scene, so that frame cannot be changed. Yes, we can consider, we can understand your issues, we can find out ways. Please don't do that. Actually, I don't think it is very right to talk me on this dais, but these are the problems we are facing. One side, we have a law to implement very strictly, and other side, people who are eager to get their things done at 11th hour. So the PCP getting a PCP registration act is a very, very, in one way, it is a very simple procedure. But if there are some issues on your side, then it gets complicated. So let us have a open communication with each other and find out ways to do it in the best possible way within the framework of the Act. These are the few things I wanted to talk about. First presentation. For my monthly reporting, very, very important. Secondly, for MTP, even I am looking after MTP also. We have forwarded one letter to state government for asking guidance about 12 weeks registration upgraded to 20 weeks and 20 weeks registration upgraded to 24 weeks. So those centers who have applied to us for registrations after September 2021, that is after amendment of the Act, we have issued them certificate with amended, upgraded limitations, that is 12 to 20 and 20 to 24. But as Dr. Patwardhan Madam rightly said, there are no written guidelines as to what is to be done for the MTP centers who are given registrations long back before this Act amendment. We have asked for a guidelines from state government, Atirikta Sanchalak. We have additional director. I've sent her a letter. As we get the guidance from her, we are going to appeal to all the MTP registered centers. Those who are willing to have upgradation, they can, but they have to submit full file as if they are applying for a new. It won't be, that this is out of my personal conversation with the authorities, that it won't be automatically upgraded. Again, all the facilities, everything inspection will be done and their file, and we will try to fasten the process so that they won't have any problem for continuing their work of doing MTPs for the patients. that's all I wanted to talk about, the legal implications and legal aspects of PCP NDT Act. And again, I will say this is a social evil, and we all should work together, not as each other's enemies, but as each other's friends and associates, I would say, and find out one or two real culprits, and things will be, I think, easier, and there should not be harassment of doctors. I try my best not to harass my colleagues, but from your side also it should be the same. That's all I wanted to share. Thank you very much, IMA and all my listeners for listening me. Sorry, I didn't prepare a presentation, but what presentation I had prepared was very act, like we have seen all the acts in Viren Kulkarni sir's presentation. So I didn't find anything new to share. So I shared my experiences.
Thank you.
Real-time experiences.
Thank you, madam. It was an excellent,
thank you very much.
Excellent talking, and most important is you gave us the confidence that we doctors and authorities we are all together. So this is very important point that you mentioned. There was one question in the chat box. I think they are some people, some doctors are from outside Pune.
Achha.
So they are asking, can you help for non-Puneite doctors? Pune doctors are more fortunate to have you with us, so they are asking this question.
I'm very sorry to say that appropriate authorities have their jurisdiction limits. So at the most newly added villages, there are 26 centers. They are also now our family. So we are now having some relationship with them also.
Yes.
I welcome them if any participants are from newly added villages. There are 26 centers.
Madam,
thank you.
That madam is given the state responsibility soon.
Yes.
I mean, definitely, madam, we wish all the best to you for being the state
Responsibility.
State responsibility.
Vaijanti, for no reason you should pray that she should be transferred from Pune to any other place. Okay, state responsibility, I am wishing that she doesn't get that. She should remain in Pune.
Dilip, I'm sure wherever she is basically Pune,
Belongs to Pune.
so she will.
And we don't want to lose her for any reason. ना कुछ भी मत करो. अगर कुछ है तो मैं वशीला लगा कि उसको बाहर भेजने का नहीं, जो भी वशीला है मैं लगाऊंगा.
Oh, Dilip, I have seen her struggling for getting answers at times from higher authorities. So if she is in that position, or everybody's problems will be solved immediately. That efficiency. Yes. All across the state, and that is why we are here. This workshop is extended to Maharashtra state for that only, that all members are benefited. Thank you, madam, for an excellent.
Thank you very much.
Yeah, thank you.
Thank you, madam. Now I request our president, Dr. B.L. Deshmukh, to felicitate you. Sir, madam, and I will request you to be present for this open forum, which will be followed by this.
Madam, this is bouquet for.
Thank you. I will collect it on Monday.
Madam, and this is IMA Pune Uparna.
Thank you. Thank you very much.
Madam.
Good evening, everybody. This is Dr. Gitanjali Sharma, Joint Secretary of Pune IMA, and now we are moving to the panel discussion and the question answer session. And to moderate this session, we have Dr. Vaijayanti Patwardhan and Dr. Meenakshi Deshpande. So let me introduce in short. Dr. Vaijayanti Patwardhan is a consultant gynecologist. She is the public health researcher and marriage and relationship counselor. त्यांची वैद्यकीय आणि सामाजिक विषयावर अनेक वृत्तपत्रातून लेखन आपण वाचलंच असेल. त्यांचं एक लोकप्रिय पुस्तक आहे जन्म बाळाचा आणि आईचाही, आणि आता त्यांची नवीन ओळख आहे ती म्हणजे शॉर्ट फिल्म निर्मिती आणि दिग्दर्शन, ज्याच्यासाठी त्यांना दादासाहेब फाळके गोल्डन कॅमेरा पुरस्कार मिळालाय. महाआरोग्य फिल्म फेस्टिवल 2020 मध्ये उल्लेखनीय कलाकृती पुरस्कार आहे, आणि सामाजिक कार्यासाठी अर्थातच अनेक सन्मान आहेत, ज्याच्यात आनंदीबाई जोशी गौरव पुरस्कार, लोकमत हिरकणी पुरस्कार, नवदुर्गा पुरस्कार, पुणे डॉक्टर्स असोसिएशन जीवन गौरव पुरस्कार, many more. As far as IME is concerned, this year she has a lot of responsibilities on her shoulders. She is the chairman of Women Doctors Wing of IMA State. At National IMA, she is the committee member of Safe Motherhood. She is associated with Public Health Department, and she is the MTP committee member of PMC. She has worked on Pcp PNDT advisory committee member for many years. And something really proud for me as a woman is she is the first lady president of IMA Pune after 50 years. And madam, you have been inspiration to many others. So after you, there were many women presidents of IMA. And the next in line is, of course, Dr. Meenakshi Deshpande, who is the president-elect. And so I take this pleasure to introduce Dr. Meenakshi. She is a senior consulting obstetrician and gynecologist, high-risk pregnancy consultant. She is director of Vatsalya Hospital and consultant at Krishna Hospital, Pune. She is the president-elect, as I have mentioned, for IMA Pune. She is the chairperson of IMA Pune for Medical Legal and AMS Committee. I am a National Standing Committee of Initiative for Safe Motherhood member. She is recipient of many awards. I am a headquarters Dr. Kanak Goyal Award for exemplary work in women health and family planning, Apulki Award for women in women's, for her work in women's social issues for consecutive 2 years. And I am a national and MS President Appreciation Award for 2 consecutive years. She is a master trainer for Foxy, VAW Cell. She is member Foxy representative NIMC, that is National Inspection and Monitoring Committee for PC and PNDT for Government of India. So it's my pleasure to handing over this panel discussion to Dr. Vaijayanti Patwardhan and Dr. Meenakshi Deshpande. Over to you.
So, thank you. Thank you, Gitanjali.
Thank you, Gitanjali, for the wonderful words, and it's really encouraging to see a big line of women achievers at IMA, and of course, our appropriate authority also shares, we share the pride with her also. And thank you, IMA State as well as IMA Pune for the opportunity to organize this particular workshop, which is very important for all practicing doctors and practicing center owners for MTP and Pcp Act, and of course with the amendment, with the addition of now surrogacy and ART techniques. Yeah, so Meenakshi.
We will invite the panelists now on this panel discussion. We have got 4 panelists which are new to us today, and 4 of our speakers will remain as panelists. So we will start with the senior Dr. Jayant Naurange sir. I think Dr. Vaijayanti will introduce her.
Dr. Jayant Naurange sir, I mean it's एखाद्या सूर्याला मेणबत्ती दाखवण्यासारखं सरांचे इंट्रोडक्शन आम्ही कोणी करणं म्हणजे but just for maybe some few people who are new to IMA, for them just would like to introduce you formally, sir. Sir is a practicing pediatrician, one of the leading pediatricians of the city, who has been a gold medalist at MBBS and MD, and also he is a medical legal expert whose work is recognized and needed by all doctors at all forums at national level also, and who was honored to be the 4th rank in LLB also. So sir has been a top academician, and we all experienced that during all the lectures. As far as this particular workshop is concerned, he is the chairman of Social Security Scheme of IMA Maharashtra State, and he is the vice chairman of the medical legal cell of IMA headquarters, and his visiting faculty to ILS Law College is apart from medical and legal expertise, is also a fitness freak, and then we really he's a great inspiration to all of us. He's recipient of many national, not only national but international awards, of which the one of the most prestigious award being the Bertha Holt International Award for Rehabilitation of 10,000 family deprived children in the last 40 years because of his association with the Bharatiya Samaj Seva Kendra, which is an orphanage. So, I mean,
किती जरी कमी बोलायचं म्हटलं तरी एवढं बोलल्याशिवाय सर तुमची इंट्रोडक्शन पूर्ण होणार नाही.
So we welcome you, Navrange sir, for this panelist discussion. The second is Dr. Chandrasekhar Sohoni. He is our consultant radiologist, an author and blogger and an entrepreneur. He is the past national coordinator for PCP NDT of Indian Radiological and Imaging Association. He is the member of the Ethical and Legal Committee of IRAI. He is also the member of the PCP NDT Committee of IRAI and is the editor of the MediTube, I think the radiology section. It's your YouTube, I think, Dr. Chandrasekhar. Yes. And he's a reviewer of Journal of Society of Fetal Medicine. He is also the co-founder of Scholar MD Advent LLP. So I welcome you, Dr. Chandrasekhar Sohoni, for this panel discussion.
Next, we have Dr. Santosh Kulkarni, who is basically an ophthalmologist, but he's been a very, very active member at IMA Maharashtra State also, and now at Center. He's a joint secretary of IMA Maharashtra State. He's a member of Central IMA Anti-Quackery Standing Committee, and he is the ex-chairman of PCP NDT Committee of IMA Maharashtra State, in which we have experienced so many of his actions, prompt actions against whatever injustice was faced, or whatever issues were faced by the members of IMA Maharashtra State. And he is a very good orator also. So Dr. Santosh Kulkarni is with us as a panelist.
So now we welcome Dr. Prashant Chaudhary, our third panelist. He is a managing committee member of IMA Pune. I think that is the first credential. Second is he's a state IMA Maharashtra State PCP NDT Committee co-chairman, and he's also the he's a secretary of IRAI Pune chapter, and he's a well-known radiologist, I think not only in Pune but all over Maharashtra. So welcome, Dr. Prashant Chaudhary.
He's also ex-member of PCP NDT Committee of IMA Pune, Pune Advisory Committee. He was a member of
ex-advisory. And we also now welcome our other faculties, Dr. Viren Kulkarni, Dr. Ashutosh Zape, Dr. Dilip Walke, Dr. Kalpana Balivan, madam. Please stay on because we'll be giving you question answers, and we expect you to answer all the questions. So we will start with
and Dr. Dinesh Thakre, who is the medical legal committee chairman of IMA Maharashtra State. He was to participate in this, but due to his some other assignment, he has extended his wishes, though he is not physically present with us. So welcome all the panelists, and now we will begin with the question and answer session.
Let us share the screen till then. Till then the screen is shared. We will start with the questions which are there in the chat box. So one question was there, I think who one can answer, who is related to PCP NDT. I think Valivan madam can answer this. What if the patient is illiterate and she can't sign the documents of the sonography form? Madam, are you there?
Actually, left hand thumb impression can be taken, and you can write and read it for her and take her left hand thumb impression. That is the legal way to do it either way, whether it is a PCP NDT or anything else. There is no other way you can do it.
Okay, so under the left hand thumb impression, is there to be some parents or any other husband signature? I mean, who is going to document that this is her thumb impression only?
No, no. Under the thumb impression, you can write left thumb impression of Mrs. This.
Yeah, but does it require any kind of authentication from any person? It's like for other consent. No need. Only the woman's thumb impression is sufficient.
Yes, yes. If we want to confirm it, we can. That time we can confirm it with the thumb impression sample. If at all there is an issue.
Madam, will it be a good idea to take the Aadhaar card of this person who is illiterate and giving left-hand thumb impression? Because
Aadhaar card for Aadhaar card, no, sir. Sir, in 2017 there is a GR government rule that Aadhaar card is not compulsory for all citizens of India. Okay. You cannot make it a compulsion to have a Aadhaar card. So we cannot say that give it by Aadhaar card. Now, why there is Aadhaar link to the Surrogacy Act, I don't know. But there is a clear-cut GR which says that you cannot compel to have a Aadhaar card.
Yeah, that is because of the Supreme Court decision, madam, that privacy cannot be maintained and you can't compel. But practically speaking, everybody has it.
Yes,
Right
it has a
from-
no, but this is Pune. Navrange sir, this is Pune. So if we say Aadhaar card, we are taken on a ride that you cannot make it compulsory for us. Pune,
No, not compulsory. Not compulsory. Will it be additional help to the doctor who is taking consent with the
Photo
left hand
ID,
thumb impression?
sir, photo ID can be taken. If they have
Yeah, photo
election
ID.
card, any photo ID, legible photo ID.
That will
But,
be better. Along
but
with
the thing is that they don't carry it when they come to the sonography.
Yes.
That's the problem. So what practical I'm telling is, basically we don't want to prove the identity over there. If I'm Kalpana Badiwant, I'm told I cannot write. I'm told that this is the situation there and my consent is to be there. I can just give a left thumb, write my name there. A doctor can write my name there under that. And witness is always there, the husband. If doctor feels safe with husband's signature or accompanied person's signature and name and sign, okay, that will also do. This is not underlined anywhere in the act. For a legal all purposes, if you can't sign, you can give your thumb impression.
Okay. Thank you, madam. Second question is, if the husband requests to show the baby after the scan to the relatives. So I think Dr. Viren Kulkarni would be able to answer this. If the husband requests to show the baby, and even Dr. Jappe also will be able to answer this.
Yes, actually, we should show. You know, it's a great fun kind of a thing. It's a once or twice in a lifetime that these people will be able to see their babies. But we have to be very careful. I mean, with latest technology, machines and everything, I think even the common public can see the organs. So we have to be very careful. And what we can do is right from the head till the umbilical cord insertion.
Okay.
And then we can straight away to the legs.
Yeah, what Ashutosh said is absolutely right. Nowhere in the act it is mentioned that you cannot show baby. You can show, but take precautions that you are just showing face or heart activity. That's it.
I would just like to add one thing to this, that many of these kind of questions come up repeatedly. So there is a basic principle of law that whatever is not prohibited by law is allowed. So as long as you are reasonable, like Dr. Jappe correctly said, that as long as you are reasonable, you take due precautions, that by no method should the sex be revealed to the patient in any way. There won't be any harm, but you have to be very careful.
Okay, I think that is the answer is adequate. So next question, I think Dr. Prashant and Dr. Bariwant, madam, you both can answer to this. Can we give 3D scan of the patient on WhatsApp after a scanning is being done? The sonography scans the 3D image or the recording to the patient or her relative after the scan is done.
We can give a 3D images, but while giving any images, we should take precautions that only face should be given or only hand should be given. And we should, it will be very precautious on the doctor's part while giving images that no sex or indirectly or directly also should be revealed to the patient.
So
one more thing I would like to add into this. Now the Act, PCP Act says that there should not be any way to reveal the sex of the fetus to the relatives or anybody. Right. So if we stick to this particular sentence, by giving this type of scans by WhatsApp and all, in a way, you might convey the sex of the baby. They might show that to some other doctor. They might misuse it. So precautions are to be taken. What my advice would be
not to give. Not to give or give of the face or head, something like that.
Even though it is not mentioned in the law, if you are sharing the images of scan 3D, you might reveal the sex of the baby in another way. So I think better better in a broad definition of not revealing sex of a baby. This fits into it that you can straight away refuse that we will not give it on the WhatsApp. Most of the time, they do ask for this, I think, CD or something. Films, they ask for films. You can give films only. But I don't think you should give a soft copy of this thing. This is my opinion. Because if I come across as an appropriate authority, I will take into consideration the broad guideline of PCP Act as to not reveal the sex to anybody by any way. Now, we have filed a case against a book which says eat mango of a particular tree to have a son. We have filed a case against that particular book, publisher, author, everyone. So I don't think it is a good idea to share a soft copy 3D shots.
So that is a very nice point, madam. I think that will be the very important take-home message today, that we cannot share 3D scans.
Should not.
We should
Legally,
not,
it's
or we
mentioned,
cannot.
we should not.
Any 3D or live moving images of the baby.
Yes.
Of CD as well as on WhatsApp or any other social media.
Which can reveal sex of the baby to anybody else other than you. Because if it is shared, you don't know who has told the sex of the baby.
Right, yes.
Because patients these days are very smart.
Correct.
They go to 3-4 doctors. They check your opinion with some other doctor also. So this is my opinion. Definitely, I will not quote it as a legal district, but this is my opinion.
That's a very good point, I've told you, and this is a take-home message for all the delegates who are listening today. And now we'll go to the next question. We'll first finish a little bit about sonography and then we'll go on to the MTP. In sonography, I've got 1 or 2 questions which are there. What happens if the machine which we have applied for a new registration and the acceptance of that new registration doesn't come within 90 days? So what is it deemed to be? I mean, should we take it as that machine has been accepted by the PCP appropriate authority, and is the center registered?
No.
Because that question was also asked by many people out
yes. Now, when you are taking a new registration, you are supposed to fill in the form and all necessary documents which are required, the demand draft of as per the clinic or hospital accordingly. If you submit the file, we take meeting every 1.5 months. After that, tentative sanction in the meeting, appropriate committee meeting, we give 60 days to fulfill all the required documents. Most of the time, what happens? Completion is not there, rent agreement, power of attorney is not there, or say, or some other issues regarding the registration. So we give them 60 days. Otherwise, we give after 60 days. If they don't reply with all required documents, we don't give the registration, and that particular file registration is considered as cancelled. After 60 days, we give them Form C, a letter we give that your fulfillment of all the required documents was not done within 16 days from this date. So your application is null and void, and now you have to apply a new file. But 60 days is a substantial amount. People do complete in that 60 days. So either you apply in a time when 2/3 of your all documents and your preparation is ready, then only you should apply. You don't make a haste of applying to the authority for registration. You wait till at least you have 2/3 of your documents of your file. So 1/3 documents you can have 60 days together.
Okay, that's quite nice.
I would just like to add one point to this.
Yes.
There was a case in Bombay High Court regarding this, and the court deliberated on this point: what to do in the interim period when the application for a renewal has been made and the certificate has not been received and no correspondence has been made to the diagnostic center or the clinic. In this case, the court said that there is a void in the act because nothing has been specified in the act what to do if a communication has not been received. So in that case, the court held that it cannot be held as illegal, even if the practitioner continues practicing till the point they receive a communication as to the rejection at least. Or if the period has completely lapsed and no communication is received, then it is granted that it is accepted. So this happened in the Bombay High Court, and that is how the court interpreted it at that time.
No, that's why I requested that before expiry of registration certificate, please do send your file 1 month and 1 week prior to your expiry date.
Correct. Absolutely.
So we have sealed machines. We have sealed machines of few hospitals because they have not given their file in time, and expiry date was over, and after that 10 days our meeting was there. So that 15 days the machine was sealed.
Correct.
We have done in some 1 or 2 cases like this.
Correct.
So keeping time is very important in this.
Yes, Madam, one more question could be regarding the scrap of old machines. As you remember, and I think you were the one who was instrumental in solving that problem, because for many years this issue was pending, especially with the busy centers when they have some old machine and then it needs to be scrapped. So what is the status now? What should be done in case somebody wants to scrap the machine? What is the
now
procedure?
Actually, the first program when we launched, the GR came in 2016, but we carried out that program in 2019, 20 and 21, 19 and 21. 66 machines were scrapped. That was the first program. So a lot of machines were in a line to get scrapped. But now I don't think there are much of machines. If they are, let us have it again, the same program. They can send us a letter by mail that we want to scrap our machine. We will see how many are there, and again we'll carry out the same exercise again.
Okay, thank you so much. Yeah.
Should we take a few questions on MTP?
Yeah.
Before that, I would like to ask Naurange sir one question on this. Sir, have you come across any cases in the last 2 years regarding MTP and PCP&DT?
Not
because
really.
I know sir is handling live cases presently and he gets cases from all over Maharashtra. So are you facing, or have you come across any persons who are facing this problem?
No, not really. When there is a direct violation of the act, it is a state-by case that it's a criminal offense only. But otherwise, delicate borderline cases or where judgment is really required, final judgment, such cases are not common.
I think this is one of the very good points, because in spite of a proper, we are getting a proper authorities and a proper implementation. The child sex ratio is also improving. Plus, there are no cases which are going on currently against any new doctors. No new doctors are getting harassed. So past 2 years, I think we have got a good improvement in the implementation status of the Maharashtra state at least. And that is a good point.
I think in the same line with this discussion, I will like to ask Dr. Santosh Kulkarni, who was the earlier chairman of PCP&DT committee of Maharashtra State, and has been active in various action committees also. So, Dr. Santosh Kulkarni, would you like to share your experiences with respect to the actions taken against doctors? Would you elaborate on that, and what should the doctors be doing in case of any litigations, or what have you been done, and what are your experiences?
Dr. Santosh Kulkarni?
Yeah. I have it.
Unmute yourself, Dr. Santosh. Unmute.
Hello.
Now we can hear.
Thank you, Dr. Vaijayanti Patwardhan madam, Dr. Meenakshi Deshpande madam. बेसिकली मी PCP&DT ला चेअरमन असल्यानंतर सर्वात पहिल्यांदा पुणे म्युनिसिपल कॉर्पोरेशनच्या बळीवंत मॅडम त्यावेळेस ॲडिशनल आरोग्य अधिकारी झाल्या होत्या, आणि मला आठवतं की डॉक्टर मीनाक्षी देशपांडे आणि मी स्वतः आम्ही बळीवंत मॅडमच्या सहकार्याने छत्रपती शिवाजी सभागृहामध्ये, पटवर्धन मॅडम पण होत्या, आपल्या सर्व गायनेकोलॉजिस्ट, सोनोलॉजिस्ट, त्याच्यानंतर रेडिओलॉजिस्ट साठी आपण एक कन्व्हर्सेशन, एक मीटिंग ठेवली होती, आणि ती खूप चांगली फ्रुटफुल झाली होती. पण PCP&DT कमिटी चेअरमन असताना मला जो एक्सपिरियन्स सांगतोय की अप्रोप्रिएट अथॉरिटी हे त्यांच्या पद्धतीने त्यांचा लॉ इम्प्लिमेंट करायचा प्रयत्न करतायत, आणि आपलं काम आहे की जो काही ऍक्ट आहे तो पाळणं. परंतु बऱ्याचदा असं झालेलं आहे की 2017-18 मध्ये अर्चना पाटील मॅडम आणि अनिता गुलाटी मॅडम, ज्या UNFPA कोऑर्डिनेटर आहेत, यांच्यासोबत आमची ज्यावेळेस मीटिंग झाली त्यावेळेस आता सध्याची मॅडम एक तुम्हाला थोडीशी विदारक स्थिती असं मी सांगू इच्छितो की जवळपास 580 केसेस ह्या 2013 ते आतापर्यंत महाराष्ट्रामध्ये फाईल झालेल्या आहेत आणि त्याच्यापैकी 280 केसेस आता पेंडिंग आहेत आणि 180 केसेस ह्या JMFC लेवलला किंवा सेशन कोर्टामध्ये निर्दोष किंवा ऍक्विटल झालेले आहेत आणि फक्त केवळ 91 केसेसमध्ये कन्व्हिक्शन झालेलं आहे. तर याच्यामध्ये बऱ्याचदा अप्रोप्रिएट ऑथॉरिटी प्रॉपर नाही आहे, याच्यामुळे झालेले आहेत. तर माझ्या आपल्या सर्व मेंबर्सना ज्यांची आपण सेक्स डिटर्मिनेशन जे करतात त्यांना आपण कधी IMA पाठीशी घातलं नाही, परंतु माझी विनंती आहे की आपल्या ज्या मेंबर्सची ज्यांची सोनोग्राफी सेंटर सील झालेले आहेत किंवा ज्यांची मशीन सील झालेली आहे त्यांना आमची विनंती आहे की आम्ही गेल्या 2 वर्षाच्या काळामध्ये ज्यांना JMFC लेवलला त्यांच्याकडनं निकाल लागलेला निर्दोष मुक्तता झालेली आहे किंवा हायकोर्टात मुक्तता झालेली आहे. बऱ्याचदा आपण खूपदा ह्या अप्रोप्रिएट ऑथॉरिटीच्या संदर्भात थोडासा भीती बाळगून त्यांना परत विचारायला जात नाही की बाबा तुम्ही माझ्याकडनं निकाल लागलेला आहे पण तुम्ही हायकोर्टात का गेला नाही, किंवा हायकोर्टात माझ्याकडनं निकाल लागलाय पण तुम्ही सुप्रीम कोर्टात का गेला नाही. तर अशा लोकांना मी सांगू इच्छितो की आपण जवळपास 2 केसेस मध्ये कोल्हापूर आणि सोलापूर ह्या 2 ठिकाणी आपण त्या मशीन डिसील करून दिलेले आहेत. कारण जसा हक्क अप्रोप्रिएट ऑथॉरिटीचा मशीन सील करायचा आहे तसा आपल्याकडनं निकाल लागल्यानंतर आपल्या डॉक्टरांचा हक्क आहे की ती डिसील करून घेणं. तर जर JMFCचा निकाल लागल्यानंतर आणि हायकोर्टाचा निकाल लागल्यानंतर आता नवरंगे सर त्याच्यावर जास्त भाष्य करतील, तर कमीत कमी 30 ते 90 दिवसापेक्षा जर जास्त दिवस झाले असतील, पण बऱ्याच केसेसमध्ये 3-3, 4-4 वर्ष ह्या केसेस रेंगाळत आहेत. तर त्याच्यामुळे माझी विनंती आहे की तुम्ही पहिल्यांदा तर स्टेटची जी PCP ॲडवायझरी कमिटी आहे त्यांना तुम्ही अर्ज करू शकता की माझ्याकडनं हा निकाल लागलेला आहे, परंतु संबंधित गव्हर्नमेंटची ऑथॉरिटी पुढे हायकोर्टात किंवा सुप्रीम कोर्टात किंवा सेशन कोर्टात जात नाहीये, तर माझं आर्थिक मानसिक सर्वच पद्धतीचं नुकसान होत आहे, अशा पद्धतीचा एक अर्ज करू शकता. स्टेटला लिगल ॲडवायझर जे आहेत भाग्यश्री अंगारी म्हणून आहेत, त्या आपल्याला वेळोवेळी मदत करतात. काही अडचण आली ती आपल्या PCPDTचे आता डॉक्टर आशुतोष जप्पे आहेत, को चेअरमन वैजयंती पटवर्धन मॅडम आहेत, त्या देखील तुम्हाला मदत करतील. तर आपण एक अर्ज देऊ शकतो आणि त्याप्रमाणे दर 3 महिन्याला तिथं जी मीटिंग होते, JJच्या HOD आहेत आपल्या राजेश्री गटके मॅडम, त्या तुम्हाला ह्याच्यातनं मदत करू शकतात. आणि जर समजा त्या ठिकाणी निकाल नाही आला तर आपण डिले कंडोनेशन करून याच्यामध्ये आपण आपली मशीन डिसील करू शकतो. हा एक केसेस आमच्याकडे आलेला. दुसरी गोष्ट, बरेचसे जुने MBBS लेवलवरचे सोनोग्राफी सेंटर्स आहेत. आता सध्या कोरोनामुळे ती एक्झाम झालेली नाही, परंतु जुने जे डॉक्टर्स आहेत ज्यांना सोनोग्राफी सेंटर्स दिलेले आहेत, परंतु आता नवीन याच्याप्रमाणे 6 महिन्याचा कोर्स त्यांना करायचा आहे. परंतु जुन्या सोनोग्राफी सेंटर्सचे जे MBBS डॉक्टर्स आहेत त्यांना तो कोर्स करायची गरज नाहीये. तर DMAR कडनं आज सकाळीच माझं डॉक्टर कानगोडे सरांशी बोलणं झालं की DMAR कडनं आपण एक CBT टेस्ट घेतो, कॉम्पिटन्सी बेस्ड टेस्ट. ही टेस्ट त्या MBBS डॉक्टरांनी द्यायची आहे. CBT टेस्ट, कॉम्पिटन्सी बेस्ड टेस्ट. ही टेस्ट DMAR कडनं घेतली जाते आणि गेल्या 3 वर्षामध्ये ही फक्त एकदाच घेतलेली आहे, ज्यावेळेस डॉक्टर तात्याराव लहाने DMAR होते. आणि आता मी स्वतः रिक्वेस्ट केलेली, आपले डॉक्टर मस्के म्हणून आहेत DMAR चे संचालक, तर त्यांना विनंती केलेली की तुम्ही परत एकदा ही टेस्ट घ्या. कारण आता नवीन जी अमेंडमेंट आलेली आहे त्याच्यामध्ये जे MBBS डॉक्टर आहेत त्यांना हा सोनोग्राफीचा 6 महिने कोर्स करायपूर्वी जर त्यांनी टेस्ट पास झाले तर त्याच्यासाठी 3 अटेम्प्ट्स आहेत. आणि आता महत्वाचा विषय असा आहे की बऱ्याचशा MBBS डॉक्टरांचे जे रिन्युअल आहे MBBSच्या सोनोग्राफी सेंटर्सचं ते पेंडिंग आहे कोरोनामुळे. तर डॉक्टर कानगोडे सरांनी सांगितलेलं आहे की त्यांचं कुणाचंही रिन्युअल थांबवलं जाणार नाही, कारण कोरोनामुळे एक्झाम घेतली गेलेली नाहीये आणि ज्यांचे 3 अटेम्प्ट्स कंप्लीट झालेले नाहीत त्यांचं रिन्युअल दिलं जाईल. जर असे कोणी MBBS डॉक्टर्स असतील आणि त्यांचं सोनोग्राफीचं रिन्युअल मिळत नसेल तर कृपया डॉक्टर आशुतोष जप्पे, डॉक्टर वैजयंती पटवर्धन मॅडम यांना PCPDT कमिटीकडे कॉन्टॅक्ट करा, आम्ही त्यांना नक्कीच मदत करू. आणि तिसरी गोष्ट, बऱ्याचशा जिल्ह्यामध्ये जे कंत्राटी विधी अधिकारी आहेत हे स्वतः इन्स्पेक्शन करतात किंवा बऱ्याचदा सिव्हिल सर्जन्स किंवा DHO त्यांना इन्स्पेक्शनला पाठवतात. तर मी स्वतः माहितीच्या अधिकारामध्ये अर्चना पाटील मॅडमकडनं विचारून घेतलेलं आहे की ह्या कंत्राटी विधी अधिकाऱ्यांना इन्स्पेक्शन करण्याची अथॉरिटी नाहीये. तर असं कुठल्या जिल्ह्यामध्ये जर आढळत असेल तर कृपया महाराष्ट्र राज्य PCPDT कमिटीचे चेअरमन डॉक्टर आशुतोष जप्पे आणि डॉक्टर वैजयंती पटवर्धन मॅडम यांच्याकडे तुम्ही कळवावं. धन्यवाद मॅडम. आजच्या कार्यक्रमामध्ये तुम्ही मला माझे अनुभव शेअर करण्याची परवानगी दिली त्याबद्दल मी डॉक्टर जयंत पटवर्धन मॅडम, डॉक्टर मीनाक्षी देशपांडे, डॉक्टर आशुतोष जपे, IMA पुणेचे डॉक्टर बाळासाहेब देशमुख सर, डॉक्टर अलका मॅडम, डॉक्टर गीतांजली मॅडम, डॉक्टर इंगळे आणि बळीवंत मॅडम यांचे मी मनपूर्वक आभार मानतो. बळीवंत मॅडम ह्या पुणे म्युनिसिपल कॉर्पोरेशनला आहेत. हे खरंच पुणेकरांचं भाग्य आहे, कारण मॅडम ज्यावेळेस पहिल्यांदा आरोग्य अधिकारी झाल्या त्यावेळेस मी पहिला फोन केला होता आणि त्या फोन नंतर त्यांनी स्वतः सुसंवाद मीटिंग घेतली होती आणि अशा पद्धतीच्या मीटिंग प्रत्येक जिल्ह्याला होणं गरजेचं आहे. धन्यवाद.
थँक्यू डॉक्टर संतोष कुलकर्णी. तुम्ही खूप चांगलं काम केलेलं आहे मागच्या ह्याच्या वर्षांमध्ये पण, आणि खूप मेंबर्स त्याच्यामुळे खूप लोकांना फायदा पण झालेला आहे. तर होप वी ऑल कंटिन्यू डुईंग गुड वर्क फॉर IMA अँड देयर आर फ्यू मोर क्वेश्चन्स.
आपल्या प्रेक्षकांनी विचारलेले प्रश्न आहेत. प्रश्न वाचते मी आधी. व्हॉट अबाउट अदर मोडॅलिटीज अदर दॅन सोनोग्राफी विच आर इन्क्लुडेड इन PCP NDT? अजून काय काय?
चंद्रशेखर सोनी, तुम्ही बोलू शकता याच्यावर. What are the other modalities of investigations which are included under PCP NDT other than a sonography machine?
CT स्कॅन आणि MRI ह्या दोन्ही मोडॅलिटीज रजिस्टर्ड लागतात डायग्नोस्टिक सेंटर, आणि त्या करून घेतल्या पाहिजेत.
आणि मला वाटतं एको, व्हॉट अबाउट 2D एको?
एको मशीन तर लागणारच, कारण इट इज अ बेसिकली सोनोग्राफी मशीन, त्यामुळे ते.
ओके, अँड व्हॉट इज द लेटेस्ट अबाउट ऑफ्थॅल्म 2B स्कॅन?
मला वाटतं ऑप्थॅल्मॉलॉजिस्टना हे मिळालं स्टे ऑर्डर हायकोर्टाकडनं 2019 साली फॉर द बी स्कॅन. कारण हायकोर्टाचं इंटरप्रिटेशन असं होतं की अंडर सेक्शन 18 ते जेनेटिक काउन्सिलिंग सेंटर, क्लिनिक किंवा लॅब होत नाही त्याच्यामुळे. बट पर्सनली आय फील की एनी मशिनरी विच इज एबल टू डिटेक्ट द सेक्स ऑफ द फिटस विल रिक्वायर रजिस्ट्रेशन.
What about this so-called blood test, which they're through the genetic test, the mother's circulating blood, fetal cells, they are able to tell the sex, and there are advertisements about this.
I think they will require registration.
Or Dr. Prashant Chaudhary can answer that.
तुम्ही पण सांगा याबद्दल.
Chandrasekhar, you can say something.
I think wherever the processing is happening, sir, they will have to get registered for the NIPT also.
Okay. Dr. Prashant Chaudhary, is he there? Okay. Dr. Jape?
Yes, of course, it has to be registered. I think it should be registered. But Central Advisory Board त्यांनी बहुतेक परमिशन घेतलेली नव्हती before inclusion of B-scan. I think that was a technical point for which they got stay order. So until they get Central Supervisory Board,
eventually they will have to, because it's a imaging technique and it can be used for sex determination. Eventually it will have to be registered.
Exactly.
So Dr. only with the stay order they are enjoying.
So madam,
तुम्ही प्रोसिजर
याच्यात the thing is that apart from X-ray has a very high level of radiation. So in pregnancy, X-ray is avoided. It is contraindicated. So apart from X-ray, all imaging techniques are under PCP NDT Act registration. In IUI, IVF, all these are also under PCP NDT Act registration. They are must, because now in even 7-8 weeks, like sir said, NIPT, you can diagnose it without sonography machine. By blood sample, you can detect sex. So there is a list of 18 procedures which are must for registration under PCP NDT Act for genetic centers also. So only X-ray, I think, only apart from X-ray, all other techniques, they are all imaging techniques. And once you have a machine, you can always buy a probe for sonography and do HD. So if you are having the imaging machine, definitely you should have a PCP NDT registration.
So, Madam,
because you are very high, you have a high potential of doing, you can imaging the fetus. That's a broad definition.
Sir, Vichar, Naurange sir,
I had on the same point, CT MRI need to be registered. That is absolutely right. But actually, it has more radiation than a plain X-ray. At least MRI. सिटी सॉरी.
ऍक्च्युली कसं आहे सर, त्याच्यामध्ये जे लिगली जे म्हटलंय तेच मी सांगितलंय. त्यात असं इम्प्लिकेशन आहे की एक्सरे इज मोर डेंजरस दॅन MRI, आणि MRI फार जास्त कॉमनली केला जात नाही. बट इट इज अवेलेबल डिव्हाइस फॉर sex determination. That is why MRI and CT scan both are. Some of the states, I don't think they are having CT scan under registration. In Maharashtra, we are definitely doing CT scan, MRI, everything for PCP registration. They need our registration. But I think I've heard from my colleagues out of Maharashtra, out other states, some of the states, they are not compelling CT scan for sonography, PCP entity registration.
Okay. So, काय question आहे की
Newly passed MBBS do USG.
Can newly passed MBBS do a sonography immediately?
नवरंगी सर तुम्ही सांगू शकता?
नवरंगी सर तुम्ही सांगा. 6 months training कशा पद्धतीने घ्यायला लागतं?
As per law, he has to take the 6 months training, and for PCP entity he is allowed, but then he has to pass that particular test, competency test.
Okay.
So I think the question probably has an intention in the mind that it was okay in the olden days, it's still allowed, but as per law it is allowed.
And same for MD medicine for 2D echo.
What's that?
Same for MD medicine.
Physician
training for that.
But if they want to go ahead with this regular for others, for cardiology they don't require regular.
Okay. Any other panelists want to suggest anything?
Yeah. So basically, once you have a postgraduate degree, you don't require additional qualification as per the Act. After MBBS, you have to go through the 6 months training rules.
Okay. So 6 months training, and suppose anybody is having a specialty course which he has undergone.
Then it is not required.
How many specialty courses are included in this? Gynecologist is included, radiologist is included, but what about
any postgraduate? Any postgraduate.
Any postgraduate course will be allowed to do a sonography. Okay. Yeah. Okay.
With 6 months training. That is the.
Yes, I would like to add one.
Yes, madam.
Yes, madam.
Common practice.
हाँ सांगा मॅडम काय?
एक common practice अशी आहे, which is observed very commonly, that 2D echos are done by MBBS people, or maybe experienced MBBS people are there who are doing 2D echo for a very long period of time, and cardiologists, they just sign the report.
Okay.
Such MBBS people, they ask for registration on their name, but technically we cannot give that. There
Okay.
are I have at least dozen of certificates, applications that they are doing 2D echo for last 10-20 years, and they are very expert in that. And I won't take the names, but big hospitals are hiring such people, and the reports are signed by cardiologists. But by law, only cardiologist or MD medicine person only can do 2D echocardiography. For 2D echo, there is no rule of 6 months training or something.
Okay.
MBBS person cannot do cardiac
echo. Okay.
2D echo.
Madam, there is one more question. I think you should be, you are the proper person. Time frame for issuing the certificate
MRC number. MRC
for
number.
new machine at existing center. This could be applicable to sonography center.
No, actually, there is no proper timeline, because it depends upon state government. That office gives us that, and what we do is, after registration certificate is given,
Yes.
we do it within 1 or 2 days. There is no timeline. We ask state people to do it fast.
Apply for that registration of the new machine.
Yes. Once you addition of machine is done, if there is addition of machine, if you are first applicant of new registration, definitely that model, machine, everything, MRC, immediately it is given with the certificate most of the time. If not, then let me know. I will look into it. If it is addition of machine, it takes some time, because inspection is done, after inspection by person, the recommendation by the inspecting doctor, then we give the MRC. But I try to make it fast. If it is getting delayed, please do call me.
Yeah, but there are delegates from all over
Outside
state.
Pune, yeah.
So for them, it may not be so. There is no specific timeline mentioned as such. It will depend on the appropriate authority for that.
Yes, how fast that action by the office.
Home message from this question will be, I think, for all over Maharashtra. If suppose you don't get your MRC number in time, you contact your local appropriate authority, write an email or write a letter and get it authorized or signed by the office of appropriate authority, so that you have a document in your register that you have already informed your authority. Yes.
And the take-home message for all doctors is to talk to the doctor directly. Most of the time, what happens, they send some administrative officer or some reporting person, non-medical person. That person doesn't have orientation. That person comes to our office, goes back, comes to our office, goes back. If doctor talks to doctor, things get understood easier and done easier.
Okay, so your message is that the doctor himself or herself should go and approach and talk with the appropriate authority in person.
No, not in person. If approachable by phone, you do by phone.
Okay.
But better to communicate.
Yes.
Maybe this thing was, this point was discussed in the PMC meeting of MTP committee, but for the benefit of all doctors, practicing doctors across the state, if there is a change in the, this is what specially happens for the corporate hospital or big hospitals, wherein the registration of the center for MTP center I'm talking about is in the name of the administrator, medical superintendent or somebody, and that person changes and there is one new signing authority. So in that case, what should be the procedure for the center? Should they apply for a new registration, or is it only the change of name of that person?
Actually, there are two aspects to this particular issue. One is, in MTP registration, the place is recognized. Doctor is just given a name as a caretaker or say a responsible person who will sign the authority against whom we can take action in any case future if you want to take. So there are two, but if there is a rule for license or registration, that it is non-transferable. So this decision has to be taken by our state government authority and us. I'm going to send a letter to state authority that can they permit us to keep the place the same, MTP registration place the same. But if the person is changed, like in sonography, we keep on changing the persons who are actually using the machine. Some doctors, sonologists, they are retired, they go, new people come. So addition and subtraction of the doctors, as it is done in PCP Act, keeping the registration number kept. We cannot compare PCP Act with MTP Act. Totally different acts. So we are going to ask guidance from state authority that whether we can do these name changes on our level, committee level. The president of the committee, MTP committee, can that person take this decision? Ki, okay, place is same, everything is same, just have an inspection, see whether everything is nice. Only the person name is changed, that person is resigned, and new person is added. That's all. That we are going to ask guidance from the state government. It is two parts. License cannot be transferred and person keep on changing. So we are going to ask the middle way. Can we do something for MTP only? PCP we cannot do. Once the person is changed, owner is changed, full process is changed.
Yes.
So for PCP it will never be done. For nursing home also it will never be done. Okay. It is non-transferable. But for MTP, we are going to have one try with the state authority. Some guidance from them. Can we do that at our level? Let us see what do they say.
Does MTP registration need a renewal like PCP? That is one question. And as on today, it's not there, right?
So next question will be for Dr. Walke, I think. Is he there?
No, he left.
Okay, then Dr. Jape or anyone can answer. What is the current scenario about registering an IVF center under PCP NDT post ART law?
I think Madam can answer.
Anybody knows this?
Actually, post ART. In ART, again, there is a provision of having an central committee, appropriate authority, then regional authority, authority for the local self-government corporations. 27 corporations are there in all over Maharashtra. As on today, we have only received the circular of this particular ART and Surrogacy Act. Formation of appropriate authority, whether the same authority of PCP will be given extended responsibility of this act, nothing has been told to us in written till today. So till we get some notification from state government, whatever today we are doing under PCP Act, we are registering IUI on clinic basis and IVF on indoor basis. Same PCP registration will be given till that time.
Okay.
Because again, second appropriate authority guidelines we have not received yet.
Yes. Okay. So I think we have taken all the questions which are there in the chat box.
No, few are remaining.
I have one question.
Okay, you can ask.
Yeah. No, there is one good question, and this is for all the panelists who had joined today. Whether anybody can approach any one of you in cases of problems or cases of issues. So this is the question for all panelists.
Yes, definitely.
Yes. Pune Corporation jurisdiction, definitely you can call me or meet me.
पुण्याच्या बाहेर डॉक्टर जपे बघू शकतील.
Mobile number, ma'am.
And for Pune jurisdiction, Dr. Kalpana Balivan madam is always there to help. Anyway, so we have got, many questions still, but I think we'll stop over here now. This last question, can a NIPT blood sample be withdrawn at a fetal medicine center registered as genetic clinic? So I think yes, because you cannot take a NIPT blood sample in any laboratory, because that laboratory has to be under PCP registration center. Then only you can take it. That is the most important, because just withdrawing blood, even if it is just the procedure of withdrawing blood, you cannot do it at any laboratory. That is the first and the last take-home message of today, that you will have to do it in a PCP registered center. So we thank all the panelists. Any other questions, any other points to be discussed? If you feel, all the panelists, we are welcoming you to talk on any other subject which you feel we might have missed.
And
yeah.
So on behalf of WDW Committee of IMA and Dr. Jape, would you like to say anything?
Thank you, everyone. Thank you, really, from bottom of my heart. Thank you very much. It was very nice program, ma'am.
Yeah, Dr. Kalpana Balivan, madam, you represented the appropriate authority and the authority on all these legalities on behalf of state and the local, of course, governing body. And really, thank you. Thanks to all the panelists, and especially I'm a Pune branch, which is my home branch, parent branch, for allowing us to conduct this. And request to all the all the delegates, if you still have any questions or personal issues, do write to IMA Pune or IMA Maharashtra State. And we, with the help of Balivan madam, though she's her jurisdiction is Pune city, but she has so much of knowledge that she, as I said earlier, she can answer to all queries for all the Maharashtra level problems also. And we will definitely try to have many more interactive sessions like this on behalf of WDW. With those words, I thank everyone.
And thank you, madam. And we really hope from the bottom of our hearts that you become the state appropriate authority for a proper implementation program all over Maharashtra, which is the need of the day.
Thank you very much for wishing good for me. Thank you very much.
Thank you, madam.
Yeah, just a moment. On behalf of Pune IMA, may I now request President Dr. Deshmukh sir to felicitate each of the panelists. Dr. Balivan madam.
Madam, this is a bouquet for you
Thank you, sir. Thank you very much.
Dr. Santosh Kulkarni. Dr. Santosh Kulkarni, sir, are you there? Yes, he's there.
Thank you, madam.
Yes.
Thank you.
This is bouquet for you.
Yes, thank you, sir. Deshmukh, sir.
Thank you.
Thank you, Sharma, madam.
Thank you. Dr. Chandrasekhar Soni.
Sir, bouquet for you.
Dr. Ashutosh Dape and Dr. Virendra Kulkarni.
All the panelists who are here in the
in the auditorium.
IMA
Please
auditorium.
Please come, Dr. Naurange, sir.
Thank you so much.
Yes, this is Dr. Jape, sir. Dr. Naurange, sir.
Good evening, madam.
Dr. Jape, sir.
Thank you.
Dr. Prashant Chaudhary, sir, and Dr. Dilip Walke, sir, I think they have left, but we would like to thank them for a wonderful panel discussion. And on behalf of IMA Pune, I wish to thank all the faculty, Viren Kulkarni, Dr. Nikhil Datar, sir, Dr. Walke, Dr. Kalpana Balivant, madam. Special thanks to you because from your very busy schedule, you took out time and you gave enough information, and it was a very interactive, and we are very happy about it. This program wouldn't have been possible with two great moderators and conveners. So I would request Dr. Deshmukh sir to felicitate and thank Dr. Vaijayanti Patwardhan madam, Dr. Meenakshi Deshpande. Okay.
Yeah. Thank you. Thank you.
And
Dr. Session
I myself and Dr. Alka Khirsagar madam.
Thank you, both the secretaries.
Yeah, thank you for this wonderful program.
Dr. B.L. Deshmukh sir, support.
Yes,
Thank you very
support
much.
and encouragement.
And thank you, Dr. Pingle sir. Is he there? Dr. Pingle sir and Dr. Mangesh Patel for a very
And all the office bearers of Pune IMA and the MMC observer for today, Dr. Sanjay P. and Dr. Sanjay Patil, everyone who helped and encouraged. It was a teamwork and it was a great session. Thank you very much for all the delegates who joined.
Thank you, madam.
Thank you.
Thank you.
फोटो सगळ्यांचा
फोटो
फोटो आणि